You've got responses from everybody you expected to?
No, we have concerns and we're taking appropriate action. I'll just say that.
Okay, for if they haven't responded to your January 25th
Correct.
request.
Does anybody else on the committee have comment, concern, anything else about ACICS? Public comment?
It's certainly in flow. This isn't done.
Yeah, this is a
not
moving
done.
target for sure. Anyone? Okay. All right, well, with that, we will move on to the next order of business, which is agenda item number 9, summary of major provisions in Senate Bill 1192. Again, turning over to Joanne.
I get to speech at people a lot today, so I apologize for that. So I'm just going to go briefly through this. If anyone has any questions, please jot them down and then hit me with your best shot at the end, because this is kind of lengthy. But this is a summary that basically I sent out to all staff as a result of the passage of 1192. So we tried to hit on all of the material changes. And just so you know, we did send letters out to all institutions too with a summary, and that is on the website with the summary of the material changes. And for those of you that might be interested, our link on our webpage is current to statute. So we do have the current version of the Ed Code on our link on the website. Okay, registration of out-of-state schools. So this is big and this is new. Beginning July 1, 2017, an out-of-state private post-secondary educational institution that offers distance education to California students, residents, must register with the Bureau or is not authorized to enroll California students. Registration carries a fee of $1,500, is valid for 2 years, and requires California students pay into the the Student Tuition Recovery Fund, and the institution to comply with STRIF disclosures. Non-public higher education institutions that are non-profit and accredited are exempt from this provision. And the Bureau will be promulgating regs, we're going to be talking about those today, for creation of the registration application that will require that the school provide evidence of accreditation, approval to operate in the state of its administrative location, they have a California agent for service of process, and a copy of its catalog and enrollment agreement. We need that for the aforementioned disclosures. And then their definition is provided in statute for out-of-state private post-secondary educational institution, means a private entity without a physical presence in California that offers distance education to California students for an institutional charge. Okay, section 94874, which is exemptions. It eliminates exemption J, which was often referred to as the good school exemption. There were 9 criteria for meeting that exemption, including operating for 25 plus years and being accredited for 10 plus years. We had 5 such exempted institutions in our system, and we sent letters to all 5 of those institutions letting them know that the exemption that they were claiming was no longer valid, so they needed to either meet the requirements of a different exemption or apply for approval to operate. So, yeah.
Was that change something that the Department of the Bureau wanted, or do you know where that change came from?
I don't speak to who wanted what, I just speak to implementation of.
I was surprised to see that sort of disappear. Joanne's, I think Joanne knows.
Moving on. 9480. No exemption applies to a school that participates in Title 38 Veterans Financial Aid unless they are independent institutions of higher education, and even exempt schools may apply for and obtain a verification of exemption from the Bureau. So there is a separate exemption from the requirement that institutions not be exempt. It's confusing, but they're basically I'm talking about, oh, I don't have my statute here, I'll get it for you. The Title 38 exemption, it's way in the back.
Oh. Yeah, so can you, because I was unclear what that meant in that
All it did
context.
is reword the language in this section. Basically, you can't be exempt and still participate in Title 38. However, there is an exemption to the exemption.
So is the exemption to the exemption the new piece?
No, the exemption to the exemption was put in 1247.
Okay. So
So
what does this do to the exemption to the exemption?
this doesn't do anything to the exemption to the
Okay.
exemption as far as I can tell.
Good lord. Okay.
Welcome to my world.
Yes.
The exemption to the exemption?
No, the one that you were just talking about, amendment 92.
It's 94874, right, and you're not gonna find it in this because it's, well, this is gonna have the new stuff in it, so. Okay. It's, I have it written down, but I don't have it open right now. Okay, 94874.5, all exempt schools must, at the time of closure, provide student records to the Bureau, and if accredited, a student records retention plan approved by the accreditor is specified in California Education Code Section 94927.5. You've got a copy of this? Oh, 94874.5.
Do we have a copy?
Isn't this, this is in the materials, isn't it?
I didn't see it.
No? Okay, because I'm speeching at you. You know what, we'll get it posted on the website. There is a version of this on the website, though. I didn't realize we
There
didn't
is
have
our.
The website includes the letter that you sent to institutions that's
Right.
going through the same summary points that
Right.
you have there. It is on the website.
Okay, 94874.5, all exempt schools must at the time of closure, oh, I just said that already, sorry. But you wanted 94874.5, got it? Okay, 94874.7 changes the term of a bureau-issued verification of exemption from open-ended to 2 years, so long as the institution remains compliant with the terms of the exemption for those 2 years. Keeping in mind that there is no mandate that an exempt institution apply for verification of exemption, and I keep saying that. So there is no mandate that an exempt institution file for verification of exempt status. It's just an option. Okay. 94879 eliminates the Bureau requirement for outreach of secondary students, prospective and current private post-secondary students, moves student outreach to a new office per California Education Code Section 94949.72,
Which is the creation of the.
Office of Student Assistance and Relief. And 94949.72, that's fun, you guys practice that when you get home, 94949.72, requires the Office of Student Assistance and Relief to be established by July 1, 2017. We spoke about that earlier, that is all in process right now, trying to get those positions established. 9494972,
Real quick,
yeah.
one question. That new office is not going to handle student complaints. That's still going to be handled through the Bureau, correct?
That's correct.
Yeah.
Duties of the office will be to conduct outreach and provide information to students who have been affected by unlawful activities or institutional closures. Assistance includes how to file a complaint, how to file strict claims, how to file for student loan discharge, and to assist students on an individual basis to ensure they get available relief. The office also serves as the primary contact with the Student Aid Commission, the Office of the Chancellor of the Community Colleges, the Department of Veterans Affairs, the Consumer Financial Protection Bureau, and the United States Department of Education. The office may also provide outreach to students to provide them with information on making informed decisions in selecting post-secondary educational institutions, including, among other things, students' rights regarding performance fact sheets, enrollment agreements, cancellation and refund policies, loans, free nonprofit resources, and contacting the Bureau for assistance. The office may also conduct research concerning industry trends and enforcement actions from oversight agencies. It mandates the office to annually report to the legislature updates regarding the office's progress in protecting students and conducting its duties. So 94949.73 defines other eligible institution, and this is in the, is this in the definition section? I think it is. Other eligible institution to mean an institution whose unlawful activities or closure has resulted in its students being eligible for STRIF or other financial aid relief. Requires that the office provide individualized assistance to students of Corinthian College or other eligible institutions. So there you go, there's your other eligible institutions and why we needed to define that. To relieve or mitigate economic and educational opportunity loss. This section also requires the office to post quarterly reports to the Bureau's internet website through September 1st, 2018, with a summary of outreach activities and services provided, and to provide the legislature, DCA, and the Bureau a final report by January 1, 2019. So lots going on with that office, why it's important to get it up and running right away.
Is there a specific sunset period for that?
No.
For that, there's
That's ongoing.
ongoing.
Right, the whole law has a sunset, so.
But nothing separate.
But it's
for-
not separate than the rest of the act. 94880 changes the makeup of the advisory committee from 14 members to 12 members by eliminating the 2 employer positions. Requires the chief of the Office of Student Assistance and Relief to attend, testify, and answer questions at each advisory committee meeting. Changes, so that will be commencing with the August meeting. Changes the requirements for a quorum to a majority of the appointed members of the committee. And the Bureau interprets this to mean the majority of the filled appointed positions, including the appointed non-voting members. The Bureau interprets this to mean a majority of the filled appointed positions, including the appointed non-voting members.
So you could have 2 not voting members and a total of 5, I guess. Yes. So it'll be 6 people.
If all positions are filled, right, we need 7,
2 of us would be non-voting.
yes.
So you could have a quorum of 4 voting members.
That is correct. Because those non-voting members are also appointed. Right. Yeah, if they're all filled, right. Okay. 94885.1 and 94885.5, I grouped those together because basically it does the same thing for 2 different types of institutions. These sections are amended to allow the Bureau, upon submission of sufficient evidence showing strong progress toward accreditation, to allow up to 2 additional years to become a candidate, pre-accredited, or to become accredited. The evidence must include an amended accreditation plan outlining why the original plan was not achieved, active steps the institution is taking, and documentation from an accrediting agency demonstrating the institution's likely ability to comply. The Bureau may establish policies and procedures for this section without promulgating regulations. So for those of you that aren't familiar with this requirement, in 1247, Senate Bill 1247, back in January 2015, that went into effect, and it required all degree granting institutions to become accredited if they were not already. And there was a differentiation between those that had prior approval from the Bureau and those that were just coming on board, right? So if you had prior approval as of the date of implementation, then you had certain criteria and certain benchmarks that had to be met. And if you were a new institution applying for approval to operate, you had to submit a plan, an accreditation plan. So the law was changed to allow either one of those situations to extend that period of time for 2 years total, either to meet the initial benchmark of pre-accreditation or candidacy, or the second benchmark of final accreditation, but not both. We're not adding 4 years on, you can get 2 years total. Okay? Does that work for everybody? All right, moving on. We actually promulgated regulations around this, so I know that the ongoing members of the committee are probably familiar with this. Where am I? 94889. This section allows the Bureau to promulgate regulations in order to create a process for institutions to be granted an inactive status. However, to regain active status, an institution must apply anew for an approval to operate.
What is the point of this?
Yeah, then that's it. We actually, this is one that I do know that the Bureau was hoping to be able to put something together, but we weren't necessarily seeking the requirement that we have a whole new application, but something more along the lines of a renewal application. And I can speak to this. I'll tell you why. Because if an institution is inactive for a period of time and they come back, they may change their programs. If they change their programs, then we're looking at different curriculum and we're looking at faculty. And we need to make sure that the institution is still meeting the minimum operating standards, at least in those areas. So there is still a requirement for a review of that if an institution has voluntarily stopped operating for some reason. Okay, so. And we looked at doing this, just so you know, we looked at doing this really because of the requirement of the minimum annual fee. So if there's a minimum annual fee and the institution is not really operating, then they can opt out until such time as they, we hear about this a lot at institutions. For whatever reason, their programs have become not so attractive to students and they want to restructure or, maybe for, I don't know however many schools we have, there are that many reasons why they would want to do something different. And so we were actually looking at kind of making that fair. If you don't have students and you're not operating, that is advertising for students, then you should be able to opt out of that ongoing annual fee. Section 948, no, that's not right. Section 94905 requires written disclosures of licensing requirements for students enrolling in programs that are designed to lead to positions in a profession where voluntary licensure by a government agency is available. An example is massage therapy. That is still a voluntary process to most ends, but that needs to be disclosed to the students. What can come and what can't come out of attendance at an institution that is where they have voluntary approval. Okay. 94909, the section is amended to clarify that the school's catalog must disclose whether a graduate of the degree program will be eligible to sit for the applicable licensure exam in California and other states or become certified or registered for the applicable profession in California. 94923, this section is amended, and this is strict. So this section is amended to remove the requirement for regulations in order to implement the eligibility changes that were made in Senate Bill 1247 and Senate Bill 1192. Added to this was subsection B2D, B like boy, small b like boy, 2, capital D like David, which makes students that were enrolled in all California campuses of Corinthian colleges and all California residents enrolled in distance education programs of out-of-state campuses of Corinthian colleges as of June 20th, 2014, or who withdrew within 120 days of that date, eligible for reimbursement from the Student Tuition Recovery Fund. Also added to this section is B like boy, 2, H, capital H like Henry, which allows payment of up to $500 through the Student Tuition Recovery Fund for a student who sought assistance from legal counsel that resulted in the cancellation of one or more student loans with adequate evidence, basically a legal services invoice and cancellation documentation. 3 additional amendments were added to the section. The first, a requirement that prior to a loan being paid by STRIF, the lender or servicer must provide a letter to the Bureau that upon payment of the Student Tuition Recovery Fund, the loan will no longer be collected and the lender servicer will report the loan as paid in full to all credit reporting agencies. The original letter will go to the student and the Bureau will keep a copy. 2, a provision that students have 4 years after the date of the action that made the student eligible for recovery from the Student Tuition Recovery Fund to apply for reimbursement. And 3, a provision that students are not subject to the 4-year limitation to apply for STRIF if, after a period of non-collection, the holder of the note begins collection as long as the loan would have been otherwise paid by STRIF. Section 9493.0.5, this changes the way fees are calculated from a by institution formula to a by campus formula, reduces the percentage of gross revenue collected from 2.45 of 1% from 0.75 of 1%, institutes a base amount of $2,500 and increases the cap to $60,000 for each main or branch campus, not to exceed $750,000 for any one institution. The rate is effective until July 1, 2018, when the percentage will increase to 0.55 of 1% for both main and branch campuses. These changes come with a mandate that the fees be reviewed during the 2017-18 budget process and adjusted by subsequent legislation if necessary. The section also is amended to allow the Bureau to collect $1,500 fee for an out-of-state institution registration and a $500 fee for processing applications for inactive status. Section 94932, this section contains a small amendment that mandates that the Bureau take appropriate action pursuant to the enforcement provision if the Bureau determines after completing a compliance inspection that an institution has violated any applicable law or regulations. 94934.5, this new section requires any institution with an approval to operate that knows it is being investigated by an oversight entity other than the Bureau to report the investigation and the nature of the investigation to the Bureau within 30 days of the institution's first knowledge of the investigation or face possible administrative action. For purposes of this section, oversight entity means any state or federal agency, including providers of financial aid or any attorney general or justice department. It also includes any regulator that approves the operation of the institution, the Federal Consumer Financial Protection Bureau, or the Securities and Exchange Commission, any accrediting agency, or any professional licensing entity that exercises programmatic or institutional approval. Okay. Section 94936. There are a couple of amendments to this section. The section is amended to allow the incorporation of materials obtained during a compliance inspection to be used in a citation and allows the Bureau to order compensation for student harm, including a refund of monies paid by or on behalf of a student. Section 94937. This section is amended to allow the Bureau to incorporate materials obtained or produced during a compliance inspection in investigations. Section 94944. This section raises the fee for unlicensed activity, which is operating without approval from the Bureau, from $50,000 up to $100,000. Reports to the legislature. CEC 94948. The section is amended to add information on student complaints to the director under Business and Professions Code, section 325, to the required report that the director provides to the legislature every 6 months. And 94950 is the sunset date. The sunset date is extended by 4 years from January 1, 2017 to January 1, 2021. I know, y'all lived through it.
So, just to be clear, what Joanne just provided updates on is changes to the law. So, to the extent that we have previously had people come up and demand that this law be vetoed, just a little late. So, at this point, we can open the floor to questions from the committee. Anybody? No? Okay.
Question. On the provision, the new provision that allows compensation to be awarded for student harm, are there going to be any new regulations, or is that just going to be something you take into account in your processing of inspections? How do you envision that going forward?
We feel like we already had that and we were already doing that. So it's already part of the process.
Regarding the optional licensure by the statute says any government agency, is that restricted to the state of California? I'm assuming that if a state somewhere else in the country might offer an optional licensure for a medical system, for example, that wouldn't apply.
Oh, the
here.
disclosure, let me go back and look at that.
It's 94905.
I need to go grab my statute
Oh,
and my.
Which section was that, Jeff?
it's 94905. The summary says programs that are designed to lead to positions in a profession where voluntary licensure by a government agency is available. That's super broad. I'm just curious if it refers again to California or any government agency anywhere. It's something we could take up later too. We don't have any voice on that as a committee anyway, so.
That is a good question, especially as it ties into the other new language about supposedly telling
Right,
students if
licensure.
they can be licensed in another state,
Right.
which,
Sure, it is that requires written disclosures of licensing requirements for students enrolling in programs that are designed to lead to positions in a profession where voluntary licensure by a government agency is available.
Yeah. Taking it under consideration.
I would assume the spirit of the law
Yes,
is
we're gonna have
referring
to-
to California, I
yeah.
would think.
We'll have to take this under consideration and get back to you and provide some clarification.
Thank you.
Now you got them going. That was good then.
okay. Any other committee members, questions? Anyone from the public?
Does this include international schools, or is this only domestic schools? Does this include international schools or just domestic?
We don't approve anything that's not in California.
So if a
That's-
Canadian school wanted to enroll a California student,
That would be online. This is not a requirement for online education. The registration is the only online requirement.
okay.
And then STRIF is the only disclosure that's mandated for online.
Does the Canadian school make sure STRIF is collected for the California student?
They will have to if they want to operate with approval in California,
Okay.
or authorization, I think is the word that statute uses.
One other question in that section 94905C, maybe I missed this. Is there a definition of voluntary licensure, and if not, what's the Bureau's interpretation of that?
That not mandatory. We just take the plain read on that.
Do you have any examples that would fit
Massage
that?
therapy.
Oh, I'm sorry.
Yeah, massages. So massage, if you're not familiar with it, there is a CMAT. It's I'm just not talking close enough. So in California, you are not required to be licensed by the state to be a massage therapist, but you can voluntarily undergo a test and become licensed, and that is in a lot of municipalities where you would be opening up your own shop. That license is required by them, but it's not state required. So that's an example of one of those voluntary but not required.
Is anybody aware of any others
I
besides
can't think
that?
of
Excuse me, a registered veterinary technician, is that a state? There's so many that are by private entities, basically, like medical assistants can be a certified medical assistant, but that's just a national association, it's not a government agency. Registered vet might be a California.
I believe it
registration.
is, Lisa. You know,
The registered vets are not.
yeah. they're
Yeah, so
vet
our
board.
vet would be one as well, yeah, for a vet tech program. There's not very many though, to that point. Usually the state would require licensure if they wanted it.
I assume this provision was driven by the massage. Because, yeah, it's not something that comes up.
Again, I just deal with what's handed in.
Veto this law. Okay, any other questions? Public comment? You do not need to identify yourself, sir.
My name is Margaret Ryder. In regards to the fees, it was not a great result for the sector in terms of the fee increases. We were startled to see the increases that came through the legislation, even far beyond the report that the Bureau generated on fee increase. We were able to do some demonstration of evidence that the proposed fees that are being generated under the new formula exceed what the Bureau needs for its budget. We were able to do that by doing some last-minute calculations of existing fees from membership in concerned schools, and then projected it forward in terms of the new calculations. That will continue to be a bone of contention this year and next year. And while the statute does talk about reporting to the legislature as well as continuing to look at the need for fee studies, we would hope that the Bureau would help us with that. Part of the reasons are that, certainly we want to see the Bureau funded in a way that it can fulfill its mission. We don't think the Bureau needs to overfund itself. And one of the issues that we have coming down is that fees are not generated all at once. Fees are based on the expiration of your approval dates. So they don't roll in like the IRS every,
April 15th.
you need to, So we will be conducting surveys from our members as well as interested schools in the state, asking them to give us a comparison of their current fees that they paid under the old statute and their new fees as they roll in. We would hope the Bureau will conduct a similar analysis on that so that they can, because there was some dispute between the Bureau and the association on the amount of fees that would be generated under these new guidelines. And we would like to resolve that informally before we get into a legislative fight. And one of the ways you do that, obviously, is look at the fee generation, the number of schools and what's being paid, and then try to forecast that forward to see what the annual amount would be in terms of dues collection. Partly, I think it's just good government. I think that it's important to remember, as David pointed out, that students ultimately pay these fees. They go into the cost of attending the institution. And again, while we want to see the Bureau appropriately funded based on the size of the regulated community, as well as the needs for its staffing, to collect, and again, up to $760,000 every 12 months in just license fees alone is an enormous burden, no matter how big the school is. So it is a significant amount of dollars that we're talking about. And let me address just the smaller institutions, because I know the comments that come out often on the Bureau side or the advocate side is that they're dealing with publicly traded corporations. The vast number of schools in California are small, independent, family-run, partner-owned institutions. You know, they are not financial behemoths. And the imposition of extraordinarily heavy fee costs that generate out of state entities, not just including the Bureau, by the way, really has an impact on the quality of education that they can offer their students. So it's important from a policy standpoint to appropriately fee, but make sure it's appropriate. And I think the only way you can do that is either, A, try to do some forecasting up front, do some analysis on that, try to get to a reasonable projection, or wait till the end and see what you've got. And I think that's, unfortunately, the way a lot of government accounting sometimes works. It just, we'll collect till we get to the end of it, then we'll see where we're at. And I just think that's a short-sighted way to go. So we certainly promise to publish our results, to let the Bureau know kind of what we're finding in our surveys as we go through this. And I'm hopeful that the Bureau will assign some of their staff to take a look at the fee generation for their own purposes as well. Obviously, there is a kick-up amount. It increases by 10 points if the Bureau doesn't make its fee $25 million target. It's contained in the legislation. So, you know, that's important that they kind of generate that information as well. So, appreciate the time.
Robert, to that end, we do track all of those fees separately. We've set up our accounting system to be able to do that, both mainly basically by campus, whether it's by institution code or school code. So we'll be able to track that out and see what's what. So we will be able to break that out when that conversation comes around again. Of course, that just went into effect in January, so we really haven't seen any of those fees yet, but we will be able to track that as soon as they start.
And the key metric is going to be branches. Clearly, the main fee is pretty knowable. I mean, I think we've all had some experience with that. The real unknown here is the amount of fee generation now will be assessed on branches revenues up to $60 million, which will, we believe, more than sufficiently fund the Bureau. So that's the key component that we need to see analyzed here is
Right, because that's the data we didn't have
right.
previously.
Nobody has that. Well, we never tracked that. So, thank you.
Thank you, Mr. Johnson. Any other public comment on the new statutory language? Okay, great. Moving on to the review of the Bagley-Keene Open Meeting Act information. Is this Noreen?
I got people for that.
Yeah, this is where people come in handy. Welcome. Bureau's crack legal team.
Good afternoon. My name is Mina Hamilton. I will now introduce myself, and this is my more experienced colleague, Noreen Marks. We're legal counsel to the Bureau. One of your responsibilities as members of the advisory committee is to both individually and as a body follow the Bagley-Keene Open Meeting Act. And in a nutshell, this is the law that's codified in the government code that requires that all of your discussion on advisory committee matters be done in public and open to the public. And I thought I'd just start with why is this law so important to comply with? And I'd want to quote some of the actual public state policy for the law, because I think it's nicely stated in the government code. It says, "It is the public policy of this state that public agencies exist to aid in the conduct of the people's business, and the proceedings of public agencies be conducted openly so that the public may remain informed. It's also important because a knowing violation can actually be prosecuted as a misdemeanor, and there are possibilities of civil lawsuits. So, but we want to do the right thing and follow the state policy. It's also so important, the law is so important that you're required to receive a full copy of the Bagley-Keene Open Meeting Act, and I believe Richie sent that to you, as well as a guide from our legal office. But for today, I wanted to follow the top 10 rules. It should be in your handout after agenda item number 10, just to highlight some of the important rules that focused on this advisory committee. And feel free to stop and ask questions or wait until after the presentation. But the first rule is simply that the law applies to advisory committees that consist of 3 or more persons. It actually applies to boards and subcommittees that consist of 3 or more persons. But just because this is an advisory committee does not mean that the Bagley-Keene you're exempt from the Bagley-Keene. In fact, the Education Code, the Bureau's law, specifically states that the advisory committee is subject to the Open Meeting Act. The second rule, and I think this is actually the most important, and if you just go away with this rule, keep this rule in mind at all times, is that all meetings are public. And first, what is a meeting? Under the Bagley-Keene Open Meeting Act, a meeting, the actual quote from the statute is, "Any congregation of a majority of the members of a state body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of the state body to which it pertains." So for purposes of having an advisory committee meeting, you must have a majority, and that's why we require a quorum to hold the meeting. In addition, the Act prohibits communications between a majority of the members of the advisory committee to discuss, deliberate, or take action on any item of business that is within the subject matter of the advisory committee. And this goes back again to the second rule, the important rule that all meetings are public. So your discussions related to anything for Bureau business have to be done in the public. They cannot be done through a series of communications, and that includes email communications amongst each other or telephone calls. We advise and recommend that there's no one-on-one communication between each other, such as what we call serial communications, when, for example, Kate would tell Margaret, look, this is an agenda item that's going to be discussed. I think we should talk about, have this strategy going, and then Margaret would tell Diana, and Diana would tell Gabrielle. That's a violation. There's also something we called hub and spoke communications, where Kate would contact each one of you to develop a consensus on something that you want to raise at an advisory committee meeting. There's 2 more points I want to make about the public aspect of meetings. The public has the right to attend and actually record meetings. They have the right to receive the public materials that you all receive. And for the majority of times, unless there's a technical issue, the meetings are webcast, so there's a historical record of the meetings, and that's just important to keep in mind that for challenges about the Bagley-Keene Open Meeting Act. The fourth rule is relatively new, and it's simply that the vote or abstention of each member present must be publicly reported for any action taken, and that's why you see a roll call for the minutes. It's for the purposes of future minutes that are public records, that they record each one of your votes individually or abstentions. The next 2 rules are meetings must be noticed 10 calendar days in advance, including posting on the internet, and an agenda is required that must include a description of specific items to be discussed. And generally, no item may be added to the agenda after the last day for the notice. And these rules just are to ensure that the public that may want to attend a meeting is actually given adequate notice of when the meeting will take place and the topics that are at the meeting. So that's why the agenda needs to be somewhat specific, and we work with the Bureau before they post the agenda to make sure it complies with that. It follows as a consequence, because there must be adequate notice 10 days before a meeting, that any discussions that you have related to topics that are not on the agenda actually violate the Open Meetings Act. And that's why I don't think it happens very often, but we will steer you in the right direction if we think you're going off a topic that has not been noticed properly. And generally, this is number 8, public comment must be allowed on agenda items before or during discussion of each item and before a vote. And I realize that you don't take a vote on all things, but just want to make sure that we allow public comment. We also want to allow public comment for items not on the agenda. If it's not on the agenda, again, if a public member brings up a new topic for discussion, the only option you have is, if you want to address it at the next meeting, you make it a separate agenda item for the next meeting. Because again, it hasn't been noticed adequately. And finally, you have the option of having teleconference meetings. Those are subject to the same 10-day notice requirements and agenda rules. The agenda would have to show the telephone conference location. The telephone conference locations, they can't be someone calling in on their mobile phone from their car, for example. They have to be ADA compliant, accessible to the public. And actually, at least one member must be physically present at the noticed teleconference location during the meeting. And all members must attend at a publicly noticed location. So there's a whole packet of more information about the Bagley-Keene Act, and different rules would apply to a board as opposed to advisory committee. So I just wanted to focus on the main ones here and answer any questions you may have and scare you a little bit.
It's very timely, considering that I think of everyone on this panel, only Margaret and I have been through this before.
Yeah.
So since we have so many new members, it's good for everyone to be aware of what the rules are. And we're not allowed to have in-camera conversations about things. David can't call me and ask me about, it's got to be in public.
And I should clarify that there is a rule of 2, so 2 of you can have any discussion you want about business. It's the majority of members. So right now, the majority is 5 because there's 9 filled positions. But we still recommend that you don't do the one-on-one communications because of the issues with the serial communications.
Right, once you get to 3 or
Yeah.
5 in this case.
I'm confused. So the rule is less than a majority is okay, but the recommendation is no more than 2? Or is that what you're saying?
Yes, that's accurate.
Yes, I think
I thought 2 was absolute.
even when 2 of you are discussing matters together, we think it's a good idea for you to confirm with the other person whether they've talked to anyone else, because of the ease with which a serial meeting can happen. And pretty soon you've gotten to the magic number of a majority of the body, and you've then had an illegal meeting.
And either tail of that conversation could or both. So you think you've only talked to one person, and the other person that you talk to thinks they only talked to one person, when in fact you've got 4 people involved instead of 3, and then,
Things morph. Does anybody have any questions or comments on the committee?
One question: if they're through some circumstance a group of 4 are at the same event, and can those members have a lunch together, during which time there isn't any board business discussed, or is it just a strict prohibition of
No hanging out.
co-location is wrong? You can't.
No, that is fine. There are exceptions to a meeting, and its meeting is described as, or defined as discussing matters within the jurisdiction of the body. So if you all go out to lunch together, as long as you're not discussing anything within the jurisdiction of the body, you're fine.
Understood, thank you.
Great. Anyone else? Questions, comments? Sorry. Okay, great. Thank you, ladies. Does anyone from the public have any questions about Bagley Keene? Comments? Okay. And we will move on to our next, yeah, because it's already 2. And this is just an update. This isn't conversation about, okay, to speechifying. Okay, so we do have upcoming on the agenda, the next item, which is number 11, is regulations that are already in process or published, and it's just an update. So we'll have Joanne do that, and then we'll take a quick bio break, and then we'll come back and there's draft regulatory language to discuss. And I know we have at least one person in the room who would like to comment on one of those, and so we can keep things moving along. Also, for those of us who have to fly out of here, try to keep things on schedule. So we'll do number 11, we'll take a quick break, and then we'll go through the regulatory language.
Hello again. So we have three regulatory packages that we were talking about when we had our last meeting back in May. And it's been a while. And I just wanted to give you an update on where we are with those packages. The first one is the annual report, school performance fact sheet disclosures, which are Title V, California Code of Regulations 74110 and 74112. Those regulations were approved on July 14th of 2016, and they are now being implemented. For those of you that are not aware, these regulations were specific to the to the performance fact sheet and annual reporting, and those have gone into effect. So because we had such material changes that were brought about by these regulations, the Bureau actually put together workshops for institutions and did a lot of notifying of institutions that these workshops were available. And so from, I think, late October until the actual annual report was due in December, we did a number of workshops for schools on how to properly prepare a performance fact sheet, what that underlying documentation needs to include, and information on the annual report and how that annual report should be submitted. So that is out there. It's now been incorporated. If you missed it, it's still being offered as part of our compliance workshops that are offered monthly. And if you're interested, and we always recommend institutions attend those compliance workshops to make sure you're in compliance. And that schedule is on the Bureau's website. Just look under workshops. So that is still part of that. So B is the Student Tuition Recovery Fund. We've had a couple of modifications on that. I think we're in the home stretch in that we just came out with modified language, keeping in mind that every time we go out with modified language, we narrow the scope, because we will only accept comments on those sections of the regulations that have been modified. So we just went out with modification for the Student Tuition Recovery Fund on February 7th of this year, so February 7th, 2017, which included a Spanish language application and a couple of amendments to the application. And that comment period will close on February 23rd. So if you want to make comments on any changes that were made with that, with the latest go-round of modifications, they're out there for review. And C is the compliance inspection and prioritization and complaint prioritization regulations. Title V, California Code of Regulations, Section 75200, proposed changes, and 75210 and 75300, which are new. And we just received the final internal approval. Kent's actually got the package in his hands, so that will be going over to the Office of Administrative Law, hopefully before Friday of this week. And then they have 30 days to act on that, to either send it back to us, basically reject them for modifications or whatever, or to approve them. So that's where we are with the current, with the most recent regulatory packages that we've had. And I'll take any questions on this.
Committee members? Any questions about the existing packages as they've been slowly making their way through the halls of government? Okay, anyone from the public? Okay, great. So then we will take a, what time is it? It's 2:07, so why don't we take a break to 2:15, and then we'll come back and start on agenda item 12. Am I? Oh, okay. So our next agenda item.
I think Lee will want to chime in.
Oh, sure. Okay.
We just wanted to clear one point of discussion that we had on Bagley Keene Open Meetings Act. This group has a slightly interesting aspect to it, which is that you have a shifting majority, because it's based on the number of bodies that are in the chairs at the table. So while we would often say, while it's not recommended, you could meet as a less than majority group. However, you might not, if you think, oh gee, it's only 3 of us or only 4 of us, you don't know necessarily whether or not there's been new resignations. So you now constitute a majority of the committee and didn't know it. So we just recommend caution. Again, you know, if you want to talk to one other person, that's great. The problem is you don't know who else the other person has talked to, and you can always ask. You just need to be very cautious, because you don't know with the shifting majority potential whether or not you're involving a majority of the board or the committee. It's also
I think, given that, it would also be very helpful if we do have any resignations or new appointments, if we could have Richie send an email out to all the committee members saying, you know, you now have this vacancy, or you now have this new person on the committee, you know.
So we know how many we need to be.
Yeah, we can do that. And the quorum today is.
That would be helpful, thanks. Okay, anything else? Move forward? Okay, I've just been notified by Ms. Wenzel that I am actually to be the person to discuss the proposed regulatory text, so yay me. So the first item under agenda item 12 is related to draft language regarding registration of out-of-state private post-secondary educational institutions, which Joanne covered when she was talking about the changes to the legislation, which adds a new requirement that out-of-state institutions offering distance education to California residents will need to be registered. So I'm not going to read the regulation draft language to you, but I will reference to you that it is on, it is following page 83 of the materials, and it is regulation section 71396. Wait, no, that's STRIF. That's the wrong one.
No,
Or is that
no,
the,
that is it,
that is-
because
okay.
there's a strict requirement. So
Okay.
let me provide one little piece of clarification about this, is you actually have 2 separate regulation packages sitting here in front of you. The statute was narrowly crafted to allow only emergency regulations for the application itself.
Gotcha.
And so we have to have the final full regulation package due by January 1 of 2018. So with that in mind, we thought it best to just talk about it all at once. So if you'll see the highlighted piece, that's actually the emergency reg portion.
Okay.
And then the whole package, the whole thing, will
Gotcha.
be the full regulation package. I just wanted to clarify that, because we haven't seen that before as
Yes,
as a
yeah.
committee.
Thank you, Joanne. So the packet itself has 3 pages and has what looks to be 4 actual regulatory sections in it. 71-396 being the emergency portion, which is the application for. So does anyone on the committee have any questions, comments regarding the regulations as proposed?
I just have a timing question, since we didn't see these in advance.
This is the advance. These have not been noticed yet.
No, I know that. This didn't come out in our packet.
Yeah, the
Oh,
out-of-state
okay,
wasn't-
that's what you mean.
So-
No, you're right, because we're working on, we've been
Right,
working on it
right.
until the last
Right,
minute.
that's
so
fine.
Take a
So-
minute.
No, what I'd like to do actually probably is, take more than a minute and send you some written comments or suggestions. But can I just ask the timing for this? How soon do you plan to turn this into an official proposed regulation?
As soon as possible. We have a mandate that these institutions actually be registered by July 1st of this year. So we need to get that application out as soon as possible. The full package will go through the regular process. So the application itself will be done as an emergency, and then the full package will go through the regular process.
Just a little more guidance, as soon as possible, can be at least a week from now?
Actually, the emergency regs are already in process.
They're at the
Is that-
department.
Yeah. So the emergency portion of this is at the department already.
And that's
And
just this section.
Right.
So if we had any suggestions, it's too late anyway to incorporate them?
Absolutely not, because they still have to go through the full process.
Okay, so that's what I'm trying to get, is how soon, if we have comments or suggestions on this, can we get them to you so that you can take a look at them before you put out the notice?
I would say a week, because we're pushing it to try to get these promulgated by January 1. We all know that regs take a minute, or days, or weeks, or months.
So if I understand, Joanne, what you're saying correctly, this section 71-396 is already in process for publication or for review and comment.
That is, well, emergency doesn't get review, and come on up and talk about the emergency process.
Just so that I can make sure that we spend our time here today usefully.
Well, I think it's always good. We don't have emergency regulations that often,
Right.
so it's always good to talk about the process.
Good afternoon. I'm Kent Gray. I'm Regulatory Legislative Analyst for the Bureau. The emergency regulation process, which is what's being discussed, once we do an internal approval from the department, we will then make notice of, it's called advance notice of intent for emergency regulations. There will be a 5-day period after we make the notice for public comment in lieu of the regular 45-day. We will then submit it to OAL, who has 10 working days. The first 5 of those working days, they too, all comments should be sent to both the Bureau and the OAL, and it does indicate that on the notice. They'll continue to receive comments through the first 5 days after we submit to them. Days 6 through 10 are their decision whether or not to approve. And then that's it. They become emergency regulations. Emergency regulations last for 180 days. They can be readopted twice, 2 90-day periods. Obviously, we have a deadline of January 1st, 2018 to make these permanent. And that's the other point. You have to go through the regular process, which will be full notification, full 45-day period, public hearing, et cetera, to make the regulations permanent afterwards.
And only the regulations related to out-of-state schools are going through this emergency process.
It's really only the application that's going through the emergency process.
And that's the highlighted
That's the
section.
highlighted section. Oh, and the attached
The actual
application.
application.
The actual-
Yeah, we have used the incorporation by reference to bring the application fully into the regulations.
Thank you, Ken.
Thank you.
Don't go far, okay?
Okay, I'll run away.
Okay, well, given that the time-pressed issue is just with this first section, then I would suggest, why don't we take a minute, since it's only 3 paragraphs, and if anyone on the committee has any comments, questions, concerns about that, we can talk about it and then open it to the floor. And then, as far as the rest of this package, this is going through the full 45-day, and this won't be noticed with the stuff that Ken's talking about in the emergency. This will be separate.
No, we can hold on this for any comments that come in after the meeting.
Okay.
Knowing that you just got this, that may be processed, but we did want to get it in front of the committee
Okay.
so that we can get the committee's feedback on that, because we didn't want to wait until the May meeting, because then we'd be we do have a January 1 deadline.
July.
January 1.
Next year.
January 1 of next year to get these completed.
Permanent. Gotcha. Okay.
Nothing is permanent to get them.
Nothing
to get
ever.
them approved. That makes sense. Anybody need clarification on that? Yeah. Are we good?
No, not on that,
Oh, not on that? Okay.
but I have a question on the application.
Well, since that is part of this, why don't we talk about the application too?
And it's not really the application, I'm just not remembering. On the thing about the agent for service of process, I know ordinarily for an institution, isn't there something in the statute, if they don't have an agent, then the bureau's its agent, the school's agent?
No.
Used to be, I guess, no longer.
Yeah.
No, because oftentimes the bureau is serving things, so we can't serve ourselves, or we won't serve ourselves.
These out-of-state institutions, they've got to provide the student fact sheet and all the other different type of things, correct?
No, they do not,
Why not?
because it's not required in statute.
Okay.
What if that's something that we think ought to be done, that we could talk about that, put that on the agenda for a future time as a topic to consider, to recommend to the legislature?
We don't recommend to the legislature, but
You don't, but we could, because we can, yeah.
Margaret, you can. I don't know that I would make that recommendation. Imagine there's
keeping in mind that out-of-state institutions, the definition of a private post-secondary educational institution has a physical presence requirement. So what the legislature, it's my understanding that what the legislature was trying to do was to actually make California residents STRIF eligible.
Right.
So, for institutions that might be at risk of closing. And this is a direct result of the Corinthian colleges. They, to my understanding, Corinthian colleges' online education portion was based out of Arizona. And so the California residents that were enrolled in those Corinthian colleges, Everest Online, were not eligible for reimbursement from STRIF until the legislation was passed that made them eligible for STRIF. So this is a way to avoid that in the future. And this also requires accreditation, so non-accredited institutions cannot be authorized to do business in California. Correct, distance education, thank you.
Having navigated over the last several years state authorization in most of the states, I can say there's a dizzying variety of standards by state. No two states are the same, and many, to David's point, many do require consumer disclosures for outcomes of students specific to that state. There are several, I can think of 3 or 4, that required us to publish disclosures for that students in that state.
That comes down to regulating the internet, basically, and the enforcement on that. You're probably talking about doubling the staff of the Bureau.
Right. Yeah, I'm just saying other states have in their own, some don't even have any equivalent of the Bureau at all, but some did have more rigorous requirements.
And many of them are SARA, which we are not.
Which does make things more complicated. Okay, so, given the information we have and knowing what we know, does anyone have questions, comments about the emergency highlighted section of the regulation or the application itself? The application looks complete to me based on what the requirements are. I don't have any.
And that's basically how we put it together. We simply went through the statute and what the requirements were and put them in a form.
Yeah, since there was not very many in that
I
meeting.
I have a question. Again, what does the Bureau understand or interpret affiliated institution to mean?
Affiliated institution would be one that has a physical presence in California that is affiliated with an online institution
That's out of California.
that's outside of California.
Right, that's what I'm trying to get at, is what makes it affiliated? How do you interpret what that means?
Same corporate ownership. Yeah, again, the Corinthian example.
That's pretty loose. I mean, the same corporate ownership versus, yeah, I mean, it was a nice idea. It's not gonna do anything, but this is a nice idea. I mean, anybody who wants to get around this is gonna get around this.
Are you talking about the application or the regulation or the statute as a whole?
I don't know about the whole thing, but affiliated is so loose.
But the affiliated section only is that if you happen to have an affiliated institution, then you have to listen. But it doesn't matter if you do or you don't, because if you're out of state and you have California students, you're required to be approved. If you happen to also
But
have
if
a
you're not
campus in
approved,
California,
if you're not approved, because nobody wants to look, monitor the internet, it's a nice idea, but you've gotta have institutions that want to follow the law in every state. It's just, I don't know, what happens if they're not approved? What if they don't do this stuff? What happens?
much depends on what happens with the Department of Ed state authorization rules for distance education, which are in flux right now.
With the department, assuming that it's Title IV.
Right.
Okay.
Well, the options the Bureau has ultimately, and that speaks to the rest of the regulatory package, is because there isn't really an enforcement provision, what the Bureau's options really are is to contact the Department of Education and let them know that they are not compliant, to let the accreditor know that they are not compliant, and to let their home state know that they are not compliant. And we are members of NASAPS. We talk.
If it's a accredited Title IV school, I think the worst offenders are not Title IV accredited institutions doing this online stuff.
Not Title IV accredited? Or
Not accredited, and therefore don't have access
That's
to Title
based
IV.
on what, that's not really addressed in the statute. So because it's not addressed in the statute, we can't address it in the reg. Is that right?
I think the idea is that in order to be registered, they have to demonstrate accreditation. They can only be registered by the Bureau if they are accredited.
And my comment is,
And if they
if
are,
they're not registered, and they're not accredited, and they're not Title IV, who has jurisdiction over a school in, the Puerto Rico, or wherever it might be, wherever the servers are?
so in other words, the Bureau could look at its enforcement actions, and I think you're suggesting that the challenge is trying to bring an enforcement action against a school that is outside of California.
That's always
That's
a
all.
challenge. I mean, we do that now with our unapproved activity unit. We have a whole unit dedicated to tracking down unapproved activity and making that determination whether they have a physical presence or whether they don't have a physical presence.
The physical
And then
presence
contacting them.
makes it easy. I get that, well, I shouldn't say makes
Not-
it
no,
easy,
not
easier,
yet.
I mean, compared to, because the comment was,
Depends, there's a lot of-
we can't deal with the whole internet, and I know
Right.
we can't, I mean, I think we're dealing with a Corinthian issue, is what this statute is really trying to do more than anything else.
Trying to make those students eligible for STRIF is really what we're trying to do here.
See, a student will never know when they're signing up for, you know, transferring their credits from one thing so they can get their master's or their, whatever it is, they'll never know they're supposed to pay STRIF, they'll never know they're supposed to do any of these things. They're gonna pay their pretty inexpensive $1,500 to get their whatever. It's just,
That's why we have an unapproved institution unit, which now will be unapproved, unregistered.
To your point, David, it is obviously hard to track
Very
it down.
difficult to do that.
And there will be, but if you're an institution, and I think the affiliated institution thing brings up an additional incentive, because if you are an institution that happens to have a campus in California that enrolls online students in Arizona, they're enrolled in Arizona, but they live here. You obviously want to stay in good stead with the Bureau. You're going to do what you need to do to have your Arizona institution be registered for the California students. But for those who are out in the ether, unless there's a motivation, which may be the unauthorized people tracking them down and saying, you can't be operating, pay us 50 grand or now 100 grand, you know, maybe that's the incentive, but, you know, it's always gonna be hard to find those schools that don't wanna be found. There's only so much you can do.
Well, and even then, you know, I should shut up now. But the bigger challenge for the Bureau is to find the people behind the website.
Joanne, is it your understanding that you could go after a school that didn't register, that should have registered, the same way you can go after a school that's operating that's not approved, that should be approved? Or is it your understanding that you really don't have any enforcement authority other than to refer it, say, to the Attorney General for his, you know, general prosecutorial powers, or the other agencies you mentioned?
There's no enforcement authority.
So you could theoretically use your ability to shut off their phone number or things like that you have the power to do for an unregistered or an unapproved school?
Yeah, if they're not authorized to operate, we could.
So there are some tools, but they're practically speaking limited.
Very. Again, the big ones that generally want to comply, we already hear from them.
Sure.
You know, we already get those emails or letters on an ongoing basis. And David is correct, it's more difficult to find the other ones, especially if it's kind of viewed as a, no victim kind of crime. Small dollars, whatever.
All right, any other thoughts about this small piece of the pie here? So I'm going to ask for a recommendation to the Bureau on this language, that just these 3 paragraphs here, the highlighted paragraphs, whether or not we would move the Bureau to approve this language as drafted. Thank you, David. Second?
Second.
Thank you, Joe. It says chair asks for any discussion about motion. We're discussing.
No, what are we discussing?
I would-
Oh, okay, sweet.
Okay.
Flip it around now.
No, I think the
Yeah.
discussion
Yes,
could
we
be, I would recommend we not take action, that we simply consider it and send written comments to the Bureau, rather than take action on it, since we haven't had time to talk to other folks who might have thoughts about it. So I would just say we just discuss it. If we have any ideas, that we send them to the Bureau. That's my discussion on the motion.
Gotcha.
Does the board require approval of the advisory committee to move the language forward?
We just require them to discuss it.
So what was the purpose of it? We don't need to have a motion.
No.
It was just in my script.
Oh.
Sorry. I read without question.
Recommendations, right?
We're supposed to seek recommendations, which is the whole process of the conversation.
Understood.
So if during the course of the conversation, you know, generally how it's gone in the past is, someone will say, well, I don't think this language does what you want it to do. I would recommend that you change that and do, you know, whatever. But, and that's the whole point, is to have a conversation about that and to see what the committee recommends. So, but there doesn't have to be a motion, no, it can simply be, you've got our recommendations, go do it.
Okay.
Yeah, and section 94880 sub D, I believe, of the Practice Act says sub C, I'm sorry, last sentence is the advisory committee shall make recommendations with respect to policies, practices, and regulations relating to private post-secondary education, and shall provide any assistance as may be requested by the Bureau. So the question is, how do you make those recommendations, I think?
Yeah.
Okay, so I think at the committee level, do we choose to defer, and let the board, or let the Bureau take its next steps?
I think this, Margaret, if I may, recommended that each of us individually could email.
Make comment, yeah.
Make comment via email and follow-up.
This is gonna be open to comment anyway, right?
With the
Within
one
next-
week,
within
with the
the
1
next
week
week or so.
deadline, yeah.
Okay. All right, so why don't we open the floor to public comment then, if anyone has, I'm sorry, this has been sort of a,
And was that with just respect to 71396 proposed section?
right,
That's all we're discussing right now, is that and the application?
right, yes. Public comment on the emergency regulation package, specific to the STRIF for out-of-state registrants? Anyone? Hearing none? Okay, then I think we are, our recommendation has been made and we can move forward
Yeah, so now we have the full,
to the whole.
the rest of the mess.
Right.
And that was, Marta requested that we do the same thing, have an opportunity to review it and submit comments on the other pages.
Okay. So I just need to put that on the record?
Unless somebody else wants to do something else with it.
Okay. So within the same package, we have the rest of the out-of-state registration regulatory package. Does anyone have comments or points for discussion relating to that from the committee?
That's 71397 and following, just all the non-highlighted portions.
71397, 71398, and 71399.
Haven't had time to review that, won't be able to provide feedback here.
So for the non-emergency portion of this, when do we expect that package to be up for notice and comment? Do we know? Ken?
Again, that's as soon as possible, we're looking at 2 weeks.
Yeah, at least to get it into a package.
And then,
Um,
go ahead.
No, I was gonna say, because we are on the clock, with this particular package, we would look to hopefully have comments back from, the advisory committee. And Kat, why don't you circle back with all of the members of the advisory committee in about a week? Because we don't want, lack of a comment to deem lack of a comment. So to make sure that we do hear from you.
That sounds good. So, if we don't have a formal recommendation, do we need to do any motion or anything else on this section?
If you don't know, I think the statute contemplates that the recommendation come from the committee as opposed to just individuals, so that there's the Bureau can see what the consensus is.
Although that's not really how we've operated for the last 7 years. we've had very few motions in the past.
Well, and it doesn't have to be a motion. What we've done in the past, I know, is we've gone through section by section and discussed.
Just comments of individuals.
Right, and comments, and then we actually collect those comments and make changes accordingly. So it's only, I think we've only had one motion for all of it. It's really just been, here are the comments that the advisory committee has going forward. So.
And I think normally, we would have had this information earlier, and we would come with our comments and provide them, and since this one was last
Delayed.
minute, that this is sort of outside of our normal scope, unless someone actually has had time to look at this and has comments or anything to add. I think, this one may be the exception where we have to submit our comments once everyone's had a chance to review them. As part of the normal comment period, since we won't have another meeting before these become final, I'm assuming, right, because that may,
Well,
maybe.
Before they become effective as emergency. For that was the first part. For the others, no, they won't be filed by May.
no, they won't, but will they be noted?
But, but we ordinarily
Um,
have,
That's, can't review.
we ordinarily have, if we had any, offered our recommendations before it's actually officially noticed for comment. But I think that's what was suggested, is that we just do that informally afterwards, just sending our comments to the Bureau, so that we've had a chance to look at it a little more closely. I mean, it looks pretty vanilla, but, just, I would like to try to do things with a little more time.
Then I would say that it would reflect that there's not necessarily a recommendation from the committee. It would just be addressed
Any
as
individual
any individual comments. Because once again, we don't want to, we can't, I don't think we could say, even if we heard from everybody, that there were recommendations from the committee, because if we hear from you outside of this meeting, it's as individuals, not as a.
And if you all get together, you're in violation of Bay
Yes, only to you.
What we do is that we have no objections to the language. We have no issue.
Yes.
Okay. Well, then that will conclude discussion on that agenda item. Moving on. The next item is the discussion of draft regulatory language regarding English as second language programs. That is, it looks like page 87?
We actually, just as a refresher, we actually talked about ESL programs, I'm going to say back in 2015, before we kind of got derailed with implementation of 1247 regulations, sorry about that. And just as a reminder, the reason, the rationale, because there is no, obviously, notice here or initial statement of reasons, we're looking at making these changes is the feedback we've gotten from these institutions. The intention was, when the original regulations went through, was that intensive English language programs, which are English language only, the recruitment is basically done not in the United States, and there really is no set learning objectives, because the students enroll for varied periods of time, from 3 weeks, as short as 3 weeks, to up to 12 weeks or perhaps longer, into English language programs. It's not really considered vocational, because it doesn't really lead to a job, and it's not really considered academic, because you're just learning, not just, it's insanely difficult for me, but it is learning a language. So what we've discovered is completing a performance fact sheet is basically impossible, because there are no placement outcomes to be had through any of this. So as this goes, the students are not generally eligible for STRIF, because they're not in California long enough to either have an ITIN or social security number, and they're recruited someplace not here. And oftentimes these are set up part of the problem with the language that we had was basically what we were trying to do, the requirements, we got them a little off in the original regulations. So no one could actually fit into that exemption. And we've been talking about this with a couple of different accreditors and some of these schools for a period of time. So anyway, that's why you're getting this, and they've been kind of cooking out there for a long period of time. because
Joanne,
of that.
is this for an exception to the, that's what this is for?
This is to change the definition of education offered for purposes of personal entertainment, pleasure, or enjoyment.
Which is one of the exemptions to Bureau oversight.
Correct.
Because people coming in, I mean, so these are students coming in on a visa, on a student visa. That's who the bulk of these students are. Because there's 2 accrediting bodies that will do that. I mean, and
And they have to be accredited to be able to get in,
right.
which was not one of the
That
requirements.
one back then, so
back
ASSET and
then.
the other one, so if they're accredited, and the accrediting bodies will look at it and say, do you have, is it avocational or vocational? So sometimes they could have a vocational piece, but they can't be for the people with the student visas.
Correct.
Okay.
So only English language instruction and/or other education purposes for enjoyment. Oftentimes, these programs have a cultural component. So you'll notice that none of these schools are in Fresno or Bakersfield. Basically, they're in San Francisco, San Diego, Los Angeles, or other picturesque places, because there is a cultural component with that where one of these schools in Los Angeles may have actually going to the mall as part of the curriculum, so they can learn to interact in English at the mall, or to Disneyland, or some other place, because there is a cultural piece to most of this while they're learning English. So kind of the reverse of what my daughter did when she went to Italy. I should say my son. My daughter actually learned something.
You didn't
So-
send them to Fresno.
So anyway, that's what we're trying to get to here, are those specific kinds of programs.
Thank you for the context, because when I read this, I was like, what, why?
Why are we having
why?
this conversation?
Yeah, so that's helpful
And
to
that's
better
why.
understand it.
So,
Okay, so does anyone on the committee have any comments, concerns about this amended language in this section of the?
I have a number of things, and they go to the whole thing more rather than to just one specific section by section. I would just mention, in case folks want to try to take a look back at where this all came from, according to what I was able to pull out, this was first raised in the August 12th, 2014 meeting by a letter from a group that represents a number of these schools. And then we asked for some additional information, and they came back with a follow-up letter at our November 12th, 2014 meeting with some answers to some of the questions we raised. And I understand the reasons for this, and I think that, yes, some kind of exception needs to be made. I have 2 concerns with it. One, in general, I think there are 2 concerns with this kind of program. One is that we don't want to, California has so much cachet in other countries. I'm going to a school in California. We don't want it to be used to mislead people in other countries by things that are not true, even if they're not our residents and they're not paying taxes here and so on. The other concern that I think we have to watch for is that we don't want it to spill over to ESL classes that are actually being offered to California residents. So I think an exception should be narrowly tailored to what it is that these schools explained to us they offered and why they needed it. So I have just some general points. I don't have specific language, but just some general points. And I think David raised one of these. As I understand it, these schools primarily, if not exclusively, attract or are intended to attract foreigners, either people seeking a visa for learning ESL, for taking the TOEFL test, or perhaps tourists from other countries. but I don't see that the proposed regulation is so limited. And I think that that would be important to limit it really to people who are not here locally, because otherwise you get into then, well, is this something that is represented to help them get a job in California when it really doesn't, and so on. So I think you can avoid that by just making it strictly limited to the kind of programs that they indicated that they were offering.
Margaret, if I might just say, and there's a lot of these institutions which will have both. So they will have California residents as well as the visa students.
Well, what I'm saying is the exception should be only for the visa students.
agree.
You know, that's basically what I'm
Don't
trying
make
to
it
say.
institutional, but make it who the student, you know, for the class that the student is in.
But the institution only looks like this. The institution only has this program.
You will have a lot of, the institution will have this for the visa students, and then they will also have this with a vocational component, and a lot of times Title IV for another set of students.
Right, and we don't want
Not
to
everybody.
include those. We only want, because we don't deal in programmatic exemptions, we only deal in institutional exemptions. If we're going to move forward with this, we really need to tailor it then to that type of institution only. So those institutions that had any other kind of educational component other than this English language component would not be eligible for this. It would strictly be those, what we used to call intensive English language
I
programs.
suspect that the kind that have both kind of programs are already approved for the
Yes.
most part anyway. So this is really to try to deal with those, that narrow segment that they're only soliciting foreign students.
And I know part of the issue with the ESL previously, and when I say previously, I mean way back, in the Wayback Machine, under the former Bureau, is early on, they had requirements that students take ESL from our school before we will let you in this other program, so they were hitting them twice, and,
There are a lot of problems with that kind of school, so I think we want to make sure that this is carefully tailored so it doesn't open up the can of worms to problems that we know existed in the past.
does that speak to what you were talking about, David?
Yeah,
Just wanna make
I
sure.
think so. I mean, it's just, and it's, for the school that does do both, and there's legit reasons why they would do both. If you've already got the instructors there, you can, it's a daytime, nighttime a lot of times that you're dealing with, that you wouldn't want all the fact sheets and everything else for your visa students who are only gonna be there 4 to 12 weeks before they decide, now I'm going to Florida, then I'm gonna go, because they like to go see the whole country. When they come in, they'll actually bounce from one location to another location. There's a lot of transfers. You just don't make it difficult for those students those schools to recruit those kind of students, because they employ a lot of people. I bet you there's 40 or 50 schools in this state that
We have
deal with this.
quite a few of them. But just to clarify, those institutions that have other programs outside of this particular type of program would not be eligible for this exemption. It would only be, anything else, and that's why we want to make sure we write it that way, that anything else, any vocational program or other English language program offered to, and I think to Margaret's point, to residents, is not included in this exemption.
With the team that's going out, the inspection team, they wouldn't expect to see the same thing for the visa students as they would for the California resident students.
Right now, we do,
But let me ask,
That's why we're trying to
is that?
change
You
this.
don't want to, I mean,
because they're all approved.
Well,
There's not another option.
No, so say I'm a brand new institution and I want to offer intensive English to both US citizens who don't speak English and foreign students who don't speak English, and I'm doing it in just purely a vocational, I meet all these other requirements, I'm not offering anything else. Why would the fact that I am recruiting non-English speakers who live in the US be a bar to this exemption?
I think part of that is the fact that strict eligibility right off the top, but Margaret.
The exemption is applied only at the institutional level, not at the programmatic level, so the
Right.
institution is either approved or it isn't.
That's
Right.
And in this case, they're only exempt if the only thing they do, as I read it, is offer these English intensive programs to them.
Right.
Right.
And what is
See,
not clear
I
is
think-
that it's
I-
only foreign students.
Right, that's the part I'm hung up
I
on.
think the question is, or the reason this came up was not because schools that are serving a dual purpose had a problem. It was these schools that were only offering the foreign student education that had a problem because things didn't apply to them right. So I don't think that those schools that are doing the dual purpose, at least as far as we've heard, had a problem with complying with whatever the Bureau required.
Well, the truth of the matter is, any ESL program has problem complying with that because there is no placement.
Well, it's easy to comply, they just say, we
And
don't
it
have,
says
with
zero,
zero
And
placement.
that's what we've.
Right, and that's, and if you're not expecting to be placed, then you wouldn't be surprised that the placement is zero. So you can comply, you just don't have anything to show, which makes sense.
But the recruitment is done overseas by agents. It's a whole different,
But not for the ESL program.
not for the domestic ESL.
Right.
Right, and that's, for our purposes here, let's talk about intensive English language as foreign students and ESL as residential students. Can we do that?
Wait, what was the first term?
Intensive English.
Intensive
language.
English, okay.
And I pulled that from old statute.
Okay.
Because that was in the old registration, that's what it
Okay.
was.
And you work with Asset a little bit on this, because you only two, all right, then if they're happy, I'm gonna be happy.
Okay. There was a few other things. Again, assuming we're talking about those intensive English programs, from what they explained, a lot of their recruiting goes on by independent agents overseas. And I think there needs to be something, they described that most of these schools are very involved with those agents, they visit them, et cetera. But I think there needs to be something that, if you're gonna fit this exception, then you are going to be liable for your agents. Because if we say you can't advertise that you can get a job, but their agents are, then, we're not really addressing where most of their recruitment is coming from. So I think there needs to be some language talking about their liability for the conduct of their agents.
And how do we, let me just ask you this, how do we, as a bureau, enforce a provision that has to do with something that's going on in a foreign country?
Basically, what I'm saying is that the exception says you fit this exception if you're contractually, or you're liable under California law for the conduct of I don't know the exact words, but something that says, to get this exception, you are representing to us that in fact you will take liability for your agent's conduct in misrepresenting things. I think there's a way to draft it, I don't know the exact language right now.
Or perhaps exercise due diligence in monitoring the recruitment practices of agents to be consistent with this exemption.
You have to be accredited, that is something the accreditors look at, and that there's some standard language there. But by definition, these students, because of their visa, they can't work. They're not allowed to get a job.
Right, whatever the representations are. In other words, if the representation is when you take this, then you'll be able to enroll at Stanford because you have appropriate, whatever representations are made, if they're not true, then whoever's, just as with schools here, if their agents are making representations, they are liable for those representations.
So they're liable under California law, or they're liable under, because it's not happening in California? I'm just trying to get to how we might do that.
Okay, this is a concept, I don't know, maybe we do want them to be liable under California law. I don't know, but I think that's it. Let's put it this way. Right now, I raise it as an issue that we need to be thinking about, so that we aren't just turning agents loose who can say anything. And the school says, well, I'm not representing that they can get a job, or I'm not representing this will allow them to get into Stanford. So, and I tried to have due diligence, but heck, I can't control them, they're overseas. I think that we need to be at least, specifying that they are liable. And from the way that these folks described it to us, they are very much, it isn't like they're over there and they are very much involved in what those agents are doing. But I can try to, go follow through with some more language or whatever, but just the concept I wanted to get across.
You have to be specific in what language they're making the representations in, because it has to be in the language that the student can understand the material. It gets to be, the accreditors, I know you don't like, they do a lot of this stuff to make sure it's done right. I don't know if you can even make it so that they're liable because they're bouncing around from school to school to school. They're
So-
going to 3 or 4 different states
If an
in
institution
2
is
years.
exempt under the Bureau, and you got a student complaint, like say a student came over from, Italy, because, they come here. And they were told something ridiculous, and they believed it. They came here and they did their thing, and they called the Bureau, and they said, they told me that I was gonna get my TOEFL and then I could go to Harvard. And under normal circumstances, what would the Bureau do with that information?
Basically, the Bureau would refer them back, if they're exempt, the Bureau would refer them back to their accreditor. We try to, because it's non-jurisdictional, because
Right.
they're not complying with Bureau law. So we could go back to CVIP, we could go back to their accreditor, but really that's where that lies.
Couldn't you also make a determination that they are not exempt because they violated one of the requirements for being exempt?
Well, you have to be able to prove it.
That's-
I mean, that's the whole thing. I mean, we looked at 40% of the complaints can't be proven one way or the other.
Investigate that, we'd have to go to the foreign country.
Well, not necessarily, it could be that the student is here.
Well, the student's here, but if they're alleging that they were sold something in Italy and we don't have any jurisdiction of what was being sold in Italy,
You have jurisdiction over the school that's operating here.
that's correct.
And
You could
say-
probably get volunteers to investigate though, I would guess.
Yeah, and if we could get approval,
It
it's
is
hard
pretty-
enough,
I'm guessing
hard
that-
enough getting out-of-state travel approved, let alone out-of-country travel.
Yeah, I think you can investigate these things without necessarily having to travel overseas.
And absolutely we can, but the effectiveness of that evaluation could be challenged all over the place. Because it comes down to he said, she said.
Not necessarily, I mean, there's likely to be documents and so forth, but any fraud case is usually he said, she said. And so, it's a question of the preponderance of the evidence.
Right.
I mean, yes, it probably would be difficult, but you have, but because you're exempting them, if they can't show you they meet the exemption, you are in a better position than, you're not trying to prosecute them, right? Or even fine them or anything, you're just trying to say you are or aren't exempt. And
So you want to
if-
make the condition of the exemption that they agree to,
Be liable for them.
Right, just like there are a bunch of provisions here as to what it means to be exempt, this is another provision that would say if you're going to be exempt, you have to be these things.
take responsibility for your agents.
Yeah.
How's that documented? Because we would have to ask for that documentation. What is
I
that?
think if you just stay in good standing with your accrediting body or whatever it might be, I'm trying to remember how many complaints Asset would get in the roughly 7 years I was there. 1 or 2 over 7 years from an ESL school. Because again, the first stop is gonna be New York, then they might go to Toronto, then they go to Miami, then they up in San Francisco. And so, or whatever route that might be that these students go, and they're learning English, but they're, it's
Yeah,
pretty good.
there's
it's pretty
likely
good
not going to be that many complaints, so that's one thing. The other thing is, you can require it be a provision of their contract with the student. That's one way to do it. There's different ways that you could do it, that you could require it. But anyway, let me then just raise that, go on to some other points.
Okay, and that's fine. We'll continue to ponder
Right,
how
how-
we might
how
be
to go
able to
about
see
it.
that.
The other thing is that the schools represented that when the students finish, they're not getting anything that looks like a diploma or a degree, which is good because that could be misleading. So I would think that one of the criteria would be that on completion, they can receive a certificate of participation or completion, but not a degree or diploma, something along those lines. I think there should be an explicit disclaimer that the students would get, that they would provide students, that they are not preparing them for work, they're not preparing them for college entrance, whatever, so that they understand it is just recreational English learning. They said that that's what they do, but I think an explicit disclaimer would be very helpful. There's some language I can try to draft. As far as you have language in here about them not facilitating any private loans, I think there's some standard language used in consumer provisions that talk about refer, arrange, or something like that, that we might want to add so that it, has some standard interpretation behind it. That might be helpful.
What's that last one, Margaret?
There's a provision, I guess it's in
Sub H,
G and
sub
H.
H of whatever this is.
it's G and H, does not facilitate or broker private land.
Right, yeah, and so I think there's some language about not refer, arrange, and the language we have here, but just so to include some of those that are sort of standardly used, so that it's easier for interpretation purposes. And the same thing with, below that, in 3, capital B, offered to lead, I think is not entirely clear, that maybe we could come up with some clear language. And again, I don't have the language off the top of my head, but something along the lines of represented to prepare or offered, represented to lead, something like that. I think we could come up with some language that's used as a standard.
You're talking about the leading to employment piece?
Right.
Why are we concerned that a student might get a loan to come to school in California?
What they represented to us, and again, I think we're trying to tailor this to the folks who needed an exemption because nothing fits, is that these folks don't get loans, they're not eligible for federal loans, and in order to get the visa, they have to show that they have the financial wherewithal to pay for their education.
It might be a loan in Italy that happened to make this happen.
That's fine if, I don't think this precludes the student from getting a loan, it just precludes the school from being involved in that process. So in other words, that they're not acting to induce folks to come here with, we'll get you a loan, or setting them up with a lender, or any of that kind of thing. And I think that from what they explained to us, they're not doing that, and they don't want to do that. So I'm just trying to tailor it to.
Who was the group that came and presented this a while back?
It was Ellison Wilson. Sorry.
Well, he was the one, but the name of the group is, I'll find it in a minute. But anyway, and then.
Because the smaller schools, if it's a big chain, some of this stuff might work, and it'd be like, Corinthian or ITT saying, these are the rules we can deal with, but the smaller schools, the one-stop shop in San Francisco, he's got a whole different set of realities that they
I
deal
had the
with.
impression that he's represented a lot of smaller schools, but I may be wrong. That was my impression. I think that they were saying the amounts they were charging, the number of students was fairly low. So I think these were primarily small schools.
Smaller schools usually are not represented, so that's how you know.
I think they represented about half of them that do this, he said. So anyway, those were the comments I had. I guess the only other thing is, there was a comment made that they didn't used to be under the Bureau because at one time there was a registration requirement but it didn't apply to schools that charged $2,500 or less. So I think one thing maybe to consider is, does it make sense to have some sort of a dollar cap on this? And I don't know what that amount would be, but if these are really schools that are, talking about a few weeks, that might make sense too.
They're gonna charge for housing, and they're gonna charge for every 3 or 4 week block. So, I know we talked about stacking, right, Joanne? You don't like stacking.
No, I
as
don't like
recall.
stacking.
So, but stacking happens because they think they're gonna go to Miami after this, and then they're saying, I like San Francisco, I'm gonna stay for another session. This is a good thing to exempt. But you don't want to get too prescriptive in the exemption. This stuff's been going on a long time. Student visas are student visas. They come here for a reason.
All he says is that the law firm represents a coalition of 11 entities offering English as a second language programs in California. And then somewhere else he says that that's about half of the ones that are doing it. So it's a pretty small group that we're talking about.
Does anyone else on the committee have any further comment on this section?
Just quickly to note again that there is not currently reference to only institutions who only enroll international students. It isn't conceived currently, and so under this exemption, you could have an institution which only that enrolls California residents even, that meets all the other criteria.
Right. I think Joanne's got that in her notes for additional consideration. Okay, I'm going to open the floor to public comment because I know there's one person there who has a public comment. Come on up to the table. You do not have to introduce yourself if you do not want to.
Okay.
I do want to. I'm Raymond Tribus from San Diego University for Integrative Studies, and I'd like to make some oral comments, and then I have a packet of information for the members of the committee that I'd like to leave with you after that. It's been a very interesting discussion, and our basic position on the draft regulations as we see it is one of strongly oppose, essentially on grounds that it sets up two very different sets of operating lifestyles, requirements, et cetera, for essentially similar programs depending on where they're housed. Because as we read the language here, let me back up a little bit. The U.S. Department of Homeland Security, the SEVIS program, SEVP, has two types of language schools that they deal with. One is called a standalone language school, the other is called a combined. So the standalones offer only English language programs. The combined programs have those plus possibly degree programs or vocational programs, something else. Otherwise, the English language programs are similar at the two institutions. Same kinds of students, same kinds of programs. As has been said, programs are typically done in 3 or 4 week courses, a sequence of courses, beginning 1 and 2, intermediate 1, 2, and so forth, that kind of a thing. So it would essentially mean that combined institutions would be subject to Bureau approval, would have to pay the fees, would have to go through the paperwork burden, the reporting burden, all of those kinds of things, which is appropriate. But these other schools, serving the same kind of students, offering very much the same kind of programs, would be exempt from those regulatory burdens. And we believe that that sets up a fundamentally inequitable situation between these two kinds of programs. Another point that we'd like to make is that under the 2011 law, the federal government required English language schools to have accreditation. And the majority of those standalone schools are accredited either by ASSET or CEA. Combined schools often are accredited by ACICS or WASC or one of the other large accreditors. But one of the requirements from any of those accreditors to accredit a program is that they be academic programs which are academically sound. That's the whole logic of accrediting those kinds of programs. So if they're accredited as academic programs, to then treat them as though they were not academic programs and purely recreational is, I think, a violation of the underlying assumptions that go with SEVP approval for I-20s, which is that you're coming as a student in an academic program of some nature. So we just feel that there are a lot of dissonances here. So let me just quickly walk you through what's in this little packet that I'm going to leave with you. My statement is on top. The second page is a little chart that we produced that would show where under this proposed regulation, as stated, where the operating conditions for combined schools or schools under the Bureau versus exempt schools would be. And again, remembering that they're, in terms of their English language programs, are offering very much the same kind of programs to very much the same kind of students. Then we have a series of attachments. So just for reference, we have the ASSET requirements for English language schools, also the ASSET general requirements for accreditation to make the point that they're academic in nature. And then we have a couple of specific examples that I'd like to point to. We've been in the business a long time of both degree programs and English language programs, and we deal with, in one way or another, with many of the schools, the other schools in the San Diego area. And one of the things that we have found, as students who have been to many, and as has been said, many of these students do transfer from one school to another. And some of the things that we've seen is that students coming from these exempt kind of programs, and there's some provision for exemption already in the regulations as far as I understand, don't allow students to transfer from one school to another because they have a contract with the school number one, but that's contrary to SEVP regulations, which allow students to transfer at will. Some of those schools will refuse to give a student refund because the payment was made to the agent in a foreign country, not directly to the school, and the agent pays the school. When some schools, again, we have experienced, will terminate a student if they indicate an interest in transferring, which they have to do under SEVP regulations. I'm in this school, I want to transfer to that school. First school will terminate them at that point because they're attempting to transfer. which has an impact on their immigration status. Sometimes fees are excessive. Sometimes agents overcharge and mislead students, and you've had a lot of discussion on the institution's liability for what agents say and do on their behalf. And then fundamentally, the students then don't have a consumer protection agency to protect them. And as you were just saying, Ms. Wenzel, if students in this situation call the BPPE, you have to refer them to the accreditor or some other entity because they're not regulated, they're not under the BPPE. And we have just a couple in the last part of the packet here. Many of these, our own school and many of the others have a graded series of courses, beginning 1 and 2, intermediate 1, 2, whatever words they use, but a graded series of courses to develop English proficiency. And then some of the schools, many of the schools, also offer preparation for TOEFL or IELTS, which is the equivalent of that. And that becomes not potentially vocational, but certainly higher education related. So it becomes a different kind of event especially if they're offering TOEFL. It's not purely recreational anymore. It has a clear goal in mind of qualifying for college or university admission, either at the same institution or at some other one. And then we have a couple of Yelp reviews of one of our competitor institutions in San Diego with students complaining about exactly the things I've just said. And then the final points is we're aware of at least 2 lawsuits that have been filed because students don't have a bureau to go to adjudicate complaints. Their only option left is to go to essentially small claims court. And we're aware of at least 2 such cases, and we have the case numbers of at least those 2 as examples of what students have ended up having to go through to get some kind of being made whole in the case of being treated inappropriately. So I'll end where I started, and that is we have the clear sense from the way we feel this is stated that it sets up fundamentally incompatible and inequitable ways of dealing with institutions that are offering similar programs to similar kinds of students, but the institutions end up with very different burdens of fees, regulatory compliance, reporting, and so on and so forth. And I would also add that the student performance fact sheet, yes, it's true that students student visa students can't be employed in the United States. That's one of the requirements. So the employment part of the performance fact sheet is essentially 0 or not applicable or whatever, but the program completion parts are still relevant. And the last point I'd like to make is more in the nature of a question. Over the years, I've only been with the school in my current position for 7 or 8 months, but the school has been operating well before that, obviously, doing these programs. And the question of who is a resident has been a lingering issue. And again, I don't have this personal experience, but my colleagues at the school have talked to various people at the Bureau over time to say who is a California resident. And sometimes various representatives of the Bureau have said, well, no, your foreign students who are coming to English language programs are not residents. Others have said the exact opposite, yes, they are residents. And although some students might come to our program or similar ones for a short period of time and then go to another program, maybe out in a different city or state, yes, that does happen, but many also stay at the same institution for extended period of time if they really are, especially if they're preparing to go on for higher education in the U.S. They want to go through the whole graded series of English language courses, improve their skills, prepare for TOEFL, all of that. And so they do often, in our case and in many others, do stay for extended periods of time in the U.S. and at that same school. Some transfer, but many do stay for the whole series of things. So it's a complex situation, and again, the fundamental issue from our perspective is that it sets up some quite inequitable operating circumstances for the 2 types of schools. And then let me just distribute.
Can we ask questions first? Go ahead.
Take the leftovers and put them on the table. Thank you. If you would give whatever you have remaining to Richie, so we can distribute them to the people that are here. And then we'll get these, for those of our viewing audience, we will get these comments posted on the website.
So Doctor, you would not be exempt.
Correct.
What items in here would prevent you from being exempt?
As I understand it, we, number one, we do offer I-20 visas to our students. We do offer degree programs. In our case, approximately half of our total student body are in English language programs, and the other half are in degree or university degree or certificate programs.
Okay.
And at the moment, our English language programs are accredited by ASSET, and we're in the process of trying to seek accreditation for our degree programs because of that requirement. We've been working with ACICS, and of course, that, you know that whole story right now. So where we go with that is not very clear at the moment. Any other questions?
You do not have a vocational component?
Vocational component? No.
All right, so other than the academic piece,
Academic degrees and certificates and the English language program, just those two, in our case.
okay.
I have a question.
Yes.
One thing I forgot to mention is I think that these folks that were wanting the exemption mentioned that they do rolling enrollment. Whenever the student comes in, they put them in a class, rather than having a class start on X day and you continue that class for however many weeks and then that class is over. But they come in on day 3 or week 4 or whatever, they just put them in that class wherever they think is appropriate. Now, do you have rolling enrollments in your ESL programs also?
We do once-a-week admissions on Mondays, or beginning of things. We do have regular classes that are 12 weeks long, each, and I've been using our labels, beginning 1 and 2, intermediate 1 and 2, advanced 1 and 2. Each of those is 12 weeks long. Our whole institution operates on quarter system, so 12-week quarters. We do allow students to enter on any Monday. Which level they're placed in is based on a placement test of, you know, what level they already have. And then whether they, at the end of, if they come in, let's say in week 4 or 5 or whatever of a 12-week session, what happens next depends on their performance thus far. They may have advanced far enough to move on from beginning 1 to beginning 2. They may not have and need to repeat beginning 1 again in order to progress appropriately.
And the other question I have is, other than the job placement on the fact sheets, are there any other aspects of Bureau approval that you find don't quite fit your programs?
Good question. I'm not sure I can answer intelligently. In the performance fact sheets, obviously, as I said, the employment part is essentially not applicable, but we do report the program completion, and that becomes difficult because partly under ASSET accreditation requirements, what we sign people up for is the entire sequence of 6 courses in our case, 6 quarter-long courses. And then that gets amended depending on what happens thereafter, if they change their plans, you know, the student changes their plans or whatever. So what constitutes successful completion or not? You know, clearly if someone signs up for a 12-week course and they finish that course, they've completed that course. If they come in at the beginning 2 level, and so they complete 5 out of the 6 courses, have they completed the program? Or not, you know, those definitional things get very difficult to handle. And I don't recall which way we've actually done it the most recent time we had to report, but we, you know, really had to, you know, think through that and try to be consistent, at least in the way that we report that.
Would the refund?
Thank you.
I don't mean to interrupt. Would the refund policy work for you?
We have, you know, standard refund policies which follow Bureau procedures and ASSET requirements both, so we have no problems with that.
So if the exemption didn't, or allowed
Right.
for academic degree granting programs, would you want to be exempt? Would you then be okay with this exemption thing?
No, we believe in the regulation of this sector of higher education, and we think that these programs should be regulated by the Bureau. We're not looking for ourselves to be exempt, we're looking for these folks to be also subject to appropriate regulation, as we are.
It's a lot of extra money for you.
Is there a cultural component to your program?
Of the kind you've described, very small. In each 12-week course, we have typically 1 out of the however many days are involved. Well, it's 4 days a week. our classes are 4 days a week times 12 weeks, 48 days. Typically, one of those days will be a field trip kind of a thing. But in our case, every one of those field trips, the instructor has to indicate what the educational value of that particular event is. So we don't just allow going to the mall or, just wandering. We are in Old Town San Diego, which is a very pleasant and interesting historic part of the city. Wandering around is not an acceptable way to use that time, only if there's a very clearly curriculum-related reason for that particular trip.
And do you have, is your program considered both ESL and, do you combine residents and non-residents in the same program?
Well, it depends on your definition of residence. Almost all of our students.
Living in the United States or coming in from a foreign country?
U.S. citizen,
Right, U.S. citizen or permanent resident?
Okay, that's easy. U.S. citizen or permanent resident, very few of our students in either the English language or the degree programs are U.S. citizens or permanent residents.
But you have some.
But we have yes, we have a few, but a very small number. Almost all of our students in both the degree programs and ESL are on student visas. Student visas, we issue the I-20, which qualifies them for a student visa.
Do you participate in Title IV programs?
No.
Do some, or how many of your students, I guess is a better way to put it, how
Okay.
many of your students, I'm trying to get the combined program versus other program, how many of your students that come in as either ESL or IEP students, if I can use that,
Yeah, intensive English language. Right.
program students go on to academic programs at your university?
Good question. I don't know the direct answer. Off the top of my head, I would guess maybe half of them do. Many others go on to other universities, not to our own.
So they shift around.
But, and some don't go on to university in the U.S., but many do. And some proportion, I'm guessing half. I could find that out. I don't know off the top of my head.
Okay, just trying to get
Yeah,
a picture
yeah.
of what the students look like.
Right.
Specifically there.
And
Do you use agents in other countries to recruit
no, in
students?
our understanding and I'm not sure whether this is under SEVP regulations or asset regulations or where, but no, we don't use foreign agents. We believe we're not allowed to, so we don't.
So how do you recruit in
It's
other
at
countries?
this point, it's almost entirely by word of mouth. Students who have been to our institution tell their friends and family members and whatever, and they come. We do a very small amount of advertising.
If you have someone at your school who could point us to the provision that you think prevents you from recruiting in foreign countries, you can send it in to Joanne or someone later, and
Okay,
I'd just be
I
interested to take a
think
look.
you are, I don't think, it's not a CVIS or an asset issue.
okay. I may be wrong about that. I'll
But,
investigate and
yeah,
let,
if you I could be wrong too.
okay.
Does anyone else have any questions?
The CSU system and the UC system defines California residents as someone who has gone to school for 3 years in a California high school or, obviously California high school. That's their definition of a California resident. So my question is, do you have, because their definition of a California resident was a U.S. citizen or a permanent resident, but do you have, say, undocumented students who've been here for 3 years?
No, because we require a student visa in order to enroll. So they have to be documented with a student visa. Occasionally, I think we have a few students who are permanent residents, and so they have a green card, but the great majority are on student visas, so it's documentation of one form or another.
Other questions?
How often do we have somebody come in saying, I want to be under this act?
Isn't that what your school does?
Yes. David goes from state to state offering himself up for regulation.
It's, Doctor, thank you for the
Yeah, thank you
presentation.
very much for the feedback.
Okay.
It brings up some questions. So even if you were allowed to have the academic programs and the degree granting, you would still want to be under the statute? and pay the fees.
Yes, because in our current situation, in the absence of accreditation for our degree programs, we're able to point to regulation by the state as an equivalent of accreditation while we're on the way to institutional accreditation.
And you want to be on a level playing field with your competitor down the street.
Yes,
Not necessarily, you wouldn't necessarily be on a level playing field with your competitor in Miami, but you would be with your San Diego and other California schools,
yes.
okay?
And we can't control what goes on in other states, clearly, but we could, we hope, have an impact on what happens in our own state.
We appreciate your feedback, and thank you for the report.
Thank you for your time.
Welcome.
Good afternoon, Pat Whalen, Ellison Wilson Advocacy. We represent the coalition. It's nice to see some of you again, and I'm anxious to come up and try and answer some of the questions that were asked about this proposal. Just by way of background, Bureau Chief Wenzel did a good job of explaining to you the context, but I would just add that not only did we present suggested language for this regulation, which your staff has tweaked in some respects, but it's substantially the same. It's been before you for essentially 3.5 years. And Bureau Chief Wenzel and her staff, to their credit, put other regulatory packages in front of ours because they were required to do so, but it was obviously to our clients' dismay. But you may recall that at one of the various meetings that we've come here and made presentations to you, we had Mr. Ed Howard come as well. For those of you who don't know, Ed Howard is a very articulate and passionate advocate on behalf of students and consumers, and he spoke very favorably about our proposed language. With respect to some of the comments from the advisory committee, I don't know that that I'm in a position to respond substantively to some of the suggestions, only because we do represent a coalition. We're now up to 13 institutions, and I would obviously want to check with them on any proposed languages. So I can tell you that conceptually, the whole idea was to make this exemption as narrow as possible and to address some of the concerns that were raised. With respect to the speaker right before me, I would suggest that we are not similarly situated. I've never heard of his institution before. I'm not even sure we market to the same students, but I can tell you that in conversations we've had with our clients, some of them are and have at various times considered whether they would like to expand their business model to offer other more traditional educational programs and maybe even degree granting programs. We've made it clear to them, and they understand if they do that, they're outside of the exemption, and the exemption that's being proposed. So I don't think that our schools are similarly situated to the folks that spoke before us. They've made a business decision to offer what sounds like almost a 50-50 degree program. That's fine. But nobody, I think, would come in and argue here that an institution offering degree granting programs shouldn't be subject to Bureau oversight. Well, that's not us. We don't do that. Those of us in our coalition who may at some point decide to do that won't be in our coalition anymore. Or at a minimum won't be subject to the exemption. I looked quickly through the packet that he provided. The school or institution that got the negative Yelp review is not one of ours, I'm happy to say. I get the underlying point, though, that there may well be an institution out there that gets a negative Yelp review, and I'm not here to answer for all of them. But I can tell you that the folks proposing this exemption were not the subject of that Yelp complaint or the small claims action that he attached. Lastly, let me just say what I alluded to earlier. Based on his description, and I don't want to mischaracterize it, I don't know that we are marketing to the same types of students. I need to be careful about what I say because I, of course, have the greatest respect for my clients. But our student population are largely coming from middle class to well-to-do foreign families in relatively wealthy countries who want to send their son or daughter who's maybe a junior or senior in high school or equivalent in that age, to have 4 weeks or 6 weeks or a summer in America. And they get to kind of have a total immersion in English, and they get to go see Disneyland or Fort Lauderdale or whatever it is. While some of our students do go on and take the TOEFL and maybe even try to get entry into American universities, that's not the core of our folks. We're kind of a much more cultural and tourist-oriented marketing. And so the overseas agents that we use are basically travel agents. And so I just don't know that there's a comparison to the business model that was just presented to you. And with that, I would urge, we're certainly open to discussion, and I'll take some of these points back to our clients and see if I can get you guys some feedback on some of the suggestions. Just because it has been before you for so long, and we've been struggling for so long to kind of fit a square peg into a round hole in terms of the student performance fact sheets and stuff, and the rolling enrollments. Again, that's the other thing, the rolling enrollments. We have folks that will come in on a Monday, say, they'll do kind of a mini assessment and say, well, why don't we put you in this English class? 3 weeks later, that person may have progressed more than somebody who started earlier, and we'll say, okay, well, why don't you bump up to this other class? And then a few weeks later, when they're done with their program, they'll email mom and dad and say, Mom, can I stay for another 4 weeks? If they got the money, okay. And then, so how do we determine whether that person completed a program? Because they started in the middle of one and then kind of bounced to another. I mean, it's just that it's very difficult to comply with a regulatory framework that was aimed at, largely degree granting and vocational types of institutions where we do none of that. So I would urge you to act with all deliberate speed to move this forward. Any questions?
So travel agent, is it almost like summer camp?
We offer a high-quality program.
I don't mean,
but
I'm not trying to be.
No, it is. It is largely, look, we do have some students who are older than the high school and some that are younger, but the core are high school age-ish students coming over to learn English and see the sights.
Completion of a program, typically the way the accreditors do it is if they complete their 4 weeks, they complete their 4 weeks. They sign up for another 4 weeks, they complete that, that's another completion. I mean, it's when they drop in the middle that you have an issue. But with such short programs, you rarely, if ever, the completion rates are so high.
It is, yeah, the rates themselves are high, but actually tracking them so that we can comply with the Bureau's student performance fact sheet forms.
The accrediting bodies require completion tracking, don't they?
Yes, but I don't think it's the same, because that's one of the common complaints we have on our conference calls is I essentially have to have two books of accounting here to comply with CVIS and BPPE.
Is there a standard program length with your clients?
The different schools that we have, it's my understanding, have different options. So you can sign up for, I'm going to make this up, but you might be able to sign up for a 4-week program or a 6-week or a 12-week program and have some flexibility at the initial sign up. But you can also switch once you're there, or you can leave early. So it's
the way CVIS works. You want to, the students that want to stay in the United States for a long time, go for the long period. When you switch schools, you've got to do the school that's you're already at has to let CVIS know they're leaving. Then the receiving school has to say, I'm accepting this student. So it's a thing that they deal with Homeland Security with. And if I'm getting it wrong, just although I'm maybe oversimplifying a little bit. I'm torn whether you want to be dealing with this or not.
So I guess I have a follow-up question with that. The prior speaker indicated that there was a mandate by his accreditor to sign up for programs that I believe said were 12 weeks. 12 weeks?
Courses are 12 weeks, and a series of courses makes the program.
Okay, so we're looking at a course of 12 weeks, so we're looking at a program of something that could be significantly longer than 12 weeks. So it would be interesting to me to find out kind of what the average program length is. 'Cause clearly we're, well, maybe it's not clearly, but it seems to me that we're talking about two distinct kinds of programs going on here. And so it'd be interesting to me to find out if there is a standard length, or if the accreditor requires a program longer, or if there is a standard. See, I'm thinking it's like 6 or 10 weeks. I'm just trying to reverse engineer this when I consider what my kids did, to see if there's, if we really are talking about shorter
The courses are gonna be short. Let's just say it's 4 weeks. You have, your course is 12 weeks, but usually they'll stack the courses,
Depending on how long they're staying in the States.
how long they're planning on staying in the States. So
Or
it's
at that
just
particular
because that's just how
institution.
long it goes. That's the, and the only reason I'm saying is I've probably gone through 40 or 50 files in my time with Asset, looking at all the different
For
things.
those of you that aren't aware of this, David actually was a commissioner
Yeah.
for Asset in a prior life. So
In a time machine.
I just,
that
yeah,
sort
in a
of
time
stuff.
machine. So I just want to point that out, that why he's speaking to that is because he
I finally know something. I want to share it.
wants to show off.
I can certainly work on getting that information.
I think that would be helpful as we move forward, at least for me.
I have a couple of questions. Currently, how do these schools report their completion?
I think that there is a lack of uniformity, at least amongst the ones that we've talked to. We'll get calls when it's time for them to fill out their annual reporting paperwork, and we will say, well, one of your sister schools in the coalition did it this way, and then sometimes they'll say, that's great, and sometimes they'll say, oh, that's not going to work for us. We're going to have to come up with something else. So I don't think there's one set answer.
So you don't have any standard recommendation as to how they fill out the completion? In other words, that's in the situation where you have somebody that starts in one course and they jump out of that course into another course, you don't have any standard recommendation for your coalition of schools as to how they report that?
Well, our recommendation, of course, is to do their best to comply or substantially comply with the information requested by the Bureau.
Right, and
But-
what would that be?
Since we don't actually our firm personally doesn't fill out the forms, I think we tell them what we think the Bureau requires, what we think might be considered substantial compliance if you can't do actual compliance, and then their feedback to us is, okay, that may or may not work based on the data that we have. We'll try to do something close.
And another question is, maybe David, you may even know the answer to this too, but what is the purpose for taking TOEFL test or passing TOEFL test? I understand it can be used to help a person get a job or to get into a college. Are those the primary reasons why one would want to take a TOEFL test?
My understanding is that at least of our students that take the TOEFL, the primary, vast majority of them are doing it to get into college.
Okay. And then the other question is, apart from the fact sheets, are there any other aspects of Bureau oversight that you think don't fit your coalition schools?
Well, the fees, and not just for the obvious reasons. The types of enforcement and things that the Bureau is looking for are not, we don't even have occasion to, even if we wanted to be bad actors and abusive of our students, we can't promise them jobs because they can't work. We can't promise them degrees because we don't give them to, so we're paying for a regulatory structure that has an obvious value in a certain sector of the of post-secondary education, but we're not getting the, quote, benefits of that regulation.
Except that, for example, and I have no idea, but if this Yelp complaint were true about this school, it's not part of your coalition.
Right.
But if they're misrepresenting things, then the Bureau, if they are under the Bureau's authority, the Bureau would have authority to take some sort of action.
Right.
And it wouldn't necessarily have to be with, representations about getting a job. There's myriad ways where people can make misrepresentations.
Fair enough, and I'm not going to sit here and say there's no bad actor in this sector, but the reality is that it is a very competitive market, and basically what we do is we bring a lot of foreign tourists into California who are spending their or their parents' money, and when they are deciding which campus to go to, most of our folks operate outside of California as well, when they are deciding which campus to go to, cost is an issue. And the higher the fees in California, the more likely they're going to opt to go to our Florida campus, or, So we view ourselves as actually bringing revenue in to the state in a form of cultural tourism. And so
So I guess there would be two ways to meet your concerns. One would be to set up an exemption, and the other might be to keep those schools under Bureau authority, but with some sort of language dealing with the oddities or the way the programs are different when it comes to reporting placement or completion. And I guess one concern I have about the rolling admissions, I've taught ESL myself, and rolling admissions can be useful, can work very well. But historically, we've had a lot of problems with rolling admissions in California private post-secondary schools. So I think it's where one wants to be somewhat cautious about what kind of variation you might have for completion reporting and so on. But it seems to me that those are two ways to go, one of which would probably satisfy the other person who spoke, and one which would satisfy you. So anyway, I thank you both for your comments. Very interesting.
I have one more question
Yes.
before you go. You indicated that most of these students are high school students perhaps, or not?
I would say the largest plurality would be high school age, but we certainly, I think we have some that are maybe 14-ish, and then we have some that are adults, young adults.
So the reason I ask this is because we may smack up to the definition of private post-secondary educational institution if the curriculum is actually designed for something less than an adult, or less than somebody that's completed high school or past the age of compulsory attendance, is the way the statute reads. So I'd be interested in finding out how that actually breaks down.
Okay.
The attendance actually breaks down for your institutions.
Well, you raise a great point, because in some of the folks in our coalition have had issues with the fact that their students aren't able to demonstrate, the equivalent of a high school diploma, because they're not that old, and that is currently a requirement of the Bureau when it comes to inspections and so forth. Similarly, there's a kind of paradoxically an ability to benefit test that we're required to certify. Well, they don't speak any English, that's why they're coming here. So, how do we show that they have basic English ability to benefit? So there's just all kinds of those little things that don't quite fit, but we'll get you that.
I appreciate that. And do you know, are there CVEP requirements for issuing a student visa for someone less than a high school graduate or equivalent in the country in which they reside?
I don't know, only that, as the prior gentleman said, all of our folks have to have that
Yeah.
visa, so I'll find that out.
I know we get a lot of write-ups for these schools when we do compliance inspections because they don't have that documentation.
It's only been 3.5 years?
Yeah,
All right.
I was really glad to see a quorum today.
Yeah,
I'm
Richie.
tired of prepping materials for meetings that don't happen.
So Joanne, you had mentioned the high exception rate when you have a visit, like a compliance visit. Are those visitors prepped differently, saying, hey, you're going to this school, most of this doesn't actually apply to them, or do they just go out and use the same checklist?
Well, we really can't say most of this doesn't apply to them because the
Still does.
the statute is what the statute is.
Which is
the
really
regs
the
are
root
what
of
the
the-
regs
root
are,
of
so
this
we just
issue.
have to go out and write it up, basically. Even though we know that we're dealing with an anomaly, as it were, we still have to do it. So there's that.
And they could be spending time visiting schools that really matter.
Every school matters, David.
Thank you, gentlemen, both for your input. Does anybody else have any, anything to weigh in on specifically to the ESL section? No? Committee? No? All right, well, I think we've provided recommendations, comments, thoughts, and there's going to be some follow-up, it sounds like, on this one. So I think we can move to the next item. Is there anything else we need to do on the record for this one?
Well, from the Bureau's perspective, we look forward to getting additional information and reviewing this information, and then we will take all of that under consideration, probably be back at the May meeting. It'll probably be on the agenda again. So if any of the committee has anything that they want to, let us know.
Just
Please do.
any information you do receive, can you send that out to us?
Yes.
Before the meeting, well before the meeting.
We can do that.
Do you have a subgroup that would get together and maybe rethink some of this stuff, and, on your staff? I gotta believe we're close. There's probably a compromise those two could figure out.
No, I think there's enough conversation around this, David, that unfortunately, I think we need to bring it back at least one more time to the advisory committee.
Right, but what are we gonna bring back? 'Cause somebody's gotta work on it.
Right, we have staff for that, sitting back there.
All right. No pun intended, but it's kind of foreign, right? This whole thing is.
You were just waiting to say that.
My day is complete.
Oh, okay. We have a request for a quick bio break, so we'll take 5 minutes, and anybody who needs to. And I have to leave at 4:30, so we got to come back.
We still need to close out this conversation.
Okay. So just to wrap up item 13, we have a few action items that will be happening. There's going to be some additional collection of comments and thoughts. We have some information coming from some of our public members. We're going to publish the information that we were provided to the web, right, Joanne?
Correct.
And we anticipate that we will have this item on the agenda again in May for further discussion. Good? Ready? Okay. Moving on to the next item, which is item 14, discussion of draft regulatory language regarding application processing goals and timelines, which is section 71-400 of the regulations, and it looks like the additional language is subpart D. And it is literally 2 sentences, so even if you haven't read it before you got here, I would encourage you to do so right now. Essentially, what my take on this is, Joanne, and if you have anything to add, is that we're just essentially codifying the sort of already existing policy of a 30-day turnaround from the point at which an application is complete to the approval.
It's compliant, actually.
Oh, compliant, I'm sorry.
That's correct, though.
Okay.
If you swap out complete with compliant.
I'm tired, and it started with the same letters.
I get it.
So, just for clarification, this is the time period after which an application has been, it is complete, it has been reviewed, it has been determined that everything within the application is there, it is compliant, that within that time period after that point, that 30 days to the notification.
Right, so it moves through the rest of that approval process within 30 days, so the Bureau's not hanging on to that for
Okay.
any purpose.
Okay. Does anyone have any thoughts or comments?
What if they don't in 30 days? That's what I thought.
Yes, David, at that point, you will be able to issue a notice to comply.
Actually,
to Bureau.
it's happening now, so I don't, I mean,
All right, it's fine.
unless something. Sometimes.
Yeah, I had a couple of comments. I think that the language should track actually the language in 94887, So it's compliant when something along the lines is compliant when the Bureau determines that the institution's proposed implementation, as independently verified by the Bureau, has the capacity to satisfy the minimum operating standards.
So you want to add that piece out of 94887?
I yet to replace meets the minimum operating standards. And we had, as I recall, there was a lawsuit some time ago in which the school argued that the students couldn't make their claim because the Bureau's approval had already determined that it met the operating standards. And I think the language in 94887 was to say that it, so that you don't have that legal issue, has the capacity, it's deemed
That they have the capacity.
that they have the
to make-
capacity to satisfy the minimum operating standards based on their independent, or I don't know if you need the independently verified, but that they deem that they have the capacity to satisfy them. They're not deeming that they actually do.
I get it.
Anyone else have comments on this one? No? Public? Anyone have anything they would like to add on this topic? No? Seeing none? Okay, so, does the committee have any recommendation to the Bureau regarding this, aside from Margaret's technical language correction? Okay. Do I need to do anything else on this one? Okay. Then we'll move forward with item 15, which is discussion of upcoming rulemaking packages as presented by Ms. Wenzel.
Right, and I know discussion may be a stretch, but as we move through this, we talked about the rulemaking packages, that one we just completed, 2 that are in process, these three that are being considered, and then also on deck, basically on the horizon, are 2 other regulatory packages that may end up in something looking more like 2 or 3 or 4 or 10, depending on how we break apart the minimum operating standards. So we may break it down in order to take them one at a time to deal with that. Specifically, what we're concerned about are the applications. We want to make sure that the applications are complete. We understand that there are times when an institution gets a deficiency letter simply because we didn't ask for everything that we need in order to look at that. So we want to amend the applications so that they are more complete and we get all of the information up front to try to get rid of some of that frustration that the institutions feel when they get those deficiency letters. And we want to make sure that the information that we're asking for is also compliant with statute and regulation, to make sure that we're not asking things that we don't need or whatever. And I know the exemption, the verification of exempt app is just totally obsolete because we've taken away exemptions, we've added exemptions, so we need to do that. So just so you know, we've actually started this process. We had a couple of stakeholder meetings on March 9th of last year here, and on April 25th over in the other room, the hearing room. But if anybody in our listening audience or anybody here or any of the committee members want to provide us any feedback on the minimum operating standards or on applications, prior to that, the language has not been put together yet. We're working on kind of cranking out. We've got notes about what we need to fix and how we need to fix it. We're mindful of that. But if there's anything that's particularly eating away at you, let us know and we will see if we can address it. That's really all I had about that. So, any questions on that? I guess the anticipated question is when, and we hope we have applications at the May meeting. We're hoping we have language. So in order to have those applications available for all the committee to review before then, we'd hope to get that by the beginning of April, end of March, beginning of April at minimum, so that we can get those comments incorporated and have it prepared so we don't run into the same thing we did with our emergency regs and our registration this time.
Was there anything that was done in writing as a result of those stakeholder meetings? You know, whether comments you got written up in some way that you could share?
Very few comments, overall. Kent, do we have anything?
Not, I mean, it's conceptual ideas and bubbles and balloons all over the place that
Yeah.
Okay.
point to this.
It's kind
one
of like, you
point
need to
that.
consider this, or you need to consider that, so, almost, we do have them all written down though, so we're taking that into consideration as we move forward with the language, so.
I do encourage, well, for those of you left in the room, participation in those stakeholder meetings, because I remember I came to one, and I think, Kent, you might have been the one running it, and there was 2 of us there. So, you know, to the extent people have time, can get active in that, I think it's helpful. Anything else on number 15? Anyone from the public have any thoughts, comments, concerns about number 15? No? Okay. Future agenda items, number 16. Is there anyone on the committee that has any thoughts on future agenda items?
We have made notes on the Bureau update pieces, so we've already got those as far as what you would like to see going forward on the Bureau, excuse me, on the Bureau update pieces.
And for future agenda items, you will remind us in a couple of weeks before, whatever, 3 weeks before.
We will. We usually try
We
to
can
shoot
suggest
something out
things.
to the advisory committee requesting agenda items. You didn't have that luxury this time because we still had our agenda items from, last May
August and
and
November.
August and November. So, we didn't go there this time, but we will going forward.
I have an agenda item, and that is, I have a hard time, I mean, you provide lots of information, but I have a hard time telling from that information how things are really operating, in a sense. And one thing I'm wondering, I was looking at some of the citations, and maybe this is a topic we could discuss. There will be a citation, for example, students each student admitted shall possess a high school diploma. Most student files lacked high school diplomas or the equivalent. And then the corrective was institution administrators stated and provided invoice that they are implementing the Wonderlic program. Now, is that an acceptable? Because and I don't remember the statute,
Are
but
you looking at citations or notice to comply?
I'm sorry, notices to comply.
Okay.
And I guess I have a couple of questions. One is, if there is something that has been a violation, how does one tell by looking at this that it is minor and only needs a notice to comply, or whether students were harmed? So for example, if they were supposed to have high school diplomas but didn't, those students shouldn't be enrolled at all. They should get a full refund. But I have no sense that that kind of thing is happening. And another one, 2 sample student files did not contain enrollment agreements. So I take it you're not looking at every single file to see if they have enrollment agreements. And it says they should submit their policy or procedure to ensure they're enrolled solely by means of executed enrollment agreement. But what about the students who, and we don't know that it was just 2, that's all they looked at, but if their students aren't getting enrollment agreements, are they not getting all those disclosures they're supposed to be getting in the enrollment agreement? And if so, was it just inadvertent, they forgot to put the enrollment agreement in file, or does that mean that those students really didn't get the information that they were entitled to get before they enrolled? Or another 2 sample student files did not contain the student performance fact sheets. That's the primary way, according to our statute, that students are supposed to be able to find out, will they be likely to get a job when they finish. And saying that they shall submit their policy and procedure to ensure they're provided doesn't deal with the students who didn't get those disclosures. And maybe they did, they just didn't get them put in the file, which would be a sort of a minor thing, but maybe they weren't getting those, they weren't getting that information, and those students might be entitled to some sort of redress. And so I wonder if we could have some discussion from the Bureau about, determination, or how you know from this that something was done for the students or whether it should have been done for the students in the first place. And that's what I really can't tell from a lot of this. And I think the other thing is, I would like to have more information. I think one of the key, I mean, there's all kinds of things required by the statute, but one of the key things to me is, are the students really getting accurate information about the outcomes? And I don't know how we track that with the information we're getting. We see there's fraud, other, and so forth, but how do we really know, are students really getting those, key disclosures and in a timely fashion?
Okay. Anything else from the committee?
Thank you.
I think we're gonna, the Department of Education is gonna have a Higher Education Act redo in 2018. It'd be nice to, there's gonna be a lot of changes. Some of us are gonna care about those changes. The ability to benefit of the high school issue will come up again. And it's, I have mixed emotions there. The 18 or 19-year-old that doesn't have a high school diploma is one thing versus the 35-year-old that doesn't, that just wants to learn how to drive a truck. We've got to not create barriers to people's opportunity in this state. And a lot of these things are gonna come up again, as well as some of the common definitions. For example, what is a placement? We have a definition here in California. Every accrediting body has a different one. I think the department is going to finally get one. So just when we can get on the same page as some of these other, at least the Department of Education, it would be a good idea to look that direction. We've got well over a year before a lot of this stuff comes down, but there's going to be a lot of changes.
That reminds me, there was supposed to be a Bureau internal task force or committee to look at I don't think it was to standardize disclosures, but certainly look at disclosures and compare disclosures with other agencies. Maybe a status report on that.
That report is completed and it's on the website.
Oh.
So Richie, why don't you make a note to send that link to the advisory committee members? Thank you, I appreciate you.
Which does?
The disclosure report.
Yeah, we never discussed that, did we?
No, because that came out the end of the year.
So it's complete without our input?
Well, it was contracted out. It didn't require advisory committee input. It was a contract with someone from the Sac State. So it was the Bureau shall go out and get this report done and send it to the legislature.
Did that report inform the drafting of 1129?
I don't think so because of the timing of that report. It really didn't come out until after 1192 was actually already signed, I don't think.
They came to a pretty clear conclusion with the recommendation that the Bureau publish the disclosures themselves, basically.
That was one of the, there were several recommendations. One was basically get rid of a lot of the disclosures because the students are paying attention to them. So there were a lot of, it was moved to the base wage data was one of the recommendations, and move away from the performance fact sheet being generated by institutional generated data and move to base wage. Oh, that's not in the agenda. Sorry, never mind.
We can check out the report and maybe add it as a future item for discussion. But if it is available online, then obviously everyone has access to it.
It is, so Rich is in there. Thanks for calling me out. I appreciate that.
That's why they're here.
I know, and I'm the worst offender.
Anyone from the public have something they would like to add for future discussion? You do not need to identify yourself, but you
Not
can
everyone.
if we don't know who you are.
There are people that don't know.
Laura Brown, thank you. I'd like to ask the committee to put the annual fees on the May agenda if possible, and just more specifically what the Bureau is seeing in terms of an intake and fees, amounts, et cetera, if there's a way to project how much money will come in by end of the year. And secondly, if there's any update from the Bureau in terms of what they may be providing to the legislature by way of the mandate to inform the legislature about the fees and where you're at fiscally, with regard to the 17-18 state budget. And if the committee will indulge me, I think the concern is obviously where, with respect to the branches, we're at as you mentioned, Joanna, kind of we don't know where we're at and how much fees will be coming in. And I think that's very important to legislative folks in determining how they want to raise fees, lower fees, et cetera. So I would ask that the Bureau provide an agenda item and some, more detailed information, if possible, about those fees. And on top of that, the mandate forthcoming in July, 1st, 2018, with that, increase. And I think that, by the time January 1st of 18 comes around to July 1st, you're going to have, that's only a 6-month window to effectuate a change, an urgency statute, right, in an urgency measure if we needed to lower the fees. So anything the Bureau can do to provide some information on that would be greatly appreciated.
Happy to, Lauren.
Thank you, Laura. Anybody else? I don't know if there's any public members left.
Just following up on that, I maybe this is the place to put it. I had raised questions earlier about the timing for handling complaints and inspections, and I think others had raised about licensing applications. And my question was, do we have the resources we need or not? Because I think that goes hand in hand with, are the fees that we're getting enough, too much, too little? I don't know if that can be ready by May, but whenever.
I do think it would be helpful just generally for us to have sort of a fiscal view at the quarterly meetings, whatever that is that's available. What are you seeing year over year for increases or decreases? And to Laura's point, if the schedule for annual fees for last year and this year is the same, like when schools would be paying them, we should have a pretty good idea. If Joe's school paid this much in January of 2016 and they're paying this much in January 2017, what the increase is, even if it's just year over year on a quarterly basis, and then how we're tracking on the budget, because I think that's all information that would be helpful.
Okay.
Anyone else? Comments? Agenda items? Anything? Okay. So our next meeting is May 17th? Is that right? Go back to your minutes.
May 17th,
May
yes.
17th. All right. So if there is no further business, I will ask for a motion to adjourn from one of my committee friends. Thank you, David. Seconded? Second. Thank you. I think we have to do a roll call. Well, it says Chair asks Bureau to conduct a roll call vote.
Who moved?
David moved.
David moved.
Diane seconded.
So I'll call roll. Joseph Hope? Yes. Gabrielle Jimenez? Yes. Diane Almayo?
Yes.
Margaret Harden? Catherine Lee Carey?
No, I'd like to stay longer, please. Yes.
Here. Yes. David Rice?
Get me out of here. Thank you, everyone. We'll see you in May.